Kathy. I hope you're doing well. We made it to OJ. Look, his eyes are closed. He's like, no, I'm not ready for this. Give me strength. Give me vodka. Give me something. All right. Everything's good. The speed is good. The loopy loop is good. Here we go.
Along with that, we'll be complying with the state law and notifying the coroner. Isn't that correct?
Sustained.
May I have just a second? Thank you. Commander Bushey, from the time that you notified or told Detective Phillips to make this notification at about 2:30 in the morning, and we've already covered the fact at the time the notification wasn't made, would it be in direct contravention to your order to Phillips if Phillips and Furman were standing in the street at Bundy and Dorothy waiting for the robbery homicide detectives to come until 4:30 instead of complying with your order? Wouldn't that be in direct contravention to your order?
No.
That would not be if they were just standing in the street waiting?
No.
You've already said that would be disappointing to you, the fact they didn't do it on an immediate basis. Isn't that correct?
I think the disappointment was that it did not occur sooner. There's tremendous competing priorities at a scene of that magnitude.
Right. You keep talking about the competing priorities. Competing priorities are to investigate this homicide scene as thoroughly and in accordance with state law. Isn't that correct, sir?
What?
Isn't that correct?
I'm not aware of a state law that regulates an investigation.
No. The state law regulates when you call the coroner. Are you aware of that? Well,
This was beyond the scope, Counsel.
okay. This is in response to the question. You may not be aware of that, but are you aware that the most important priority is investigating these murders? Isn't that correct?
That's correct.
All right, that's more important than notifying somebody who's not the next of kin. Isn't that correct?
Those are not in competition with one another.
It is. It's argumentative.
Are you aware of how many police officers came to that scene and how many from your division in West Los Angeles that night?
No, I'm not aware of all of them that came to the scene.
If there were more than 30 officers, would that surprise you at all, who came to that scene?
No.
All right. And of those 30, don't you think that one or two of those 30, other than the lead detectives, could have gone over and made this notification per your order to Phillips? Couldn't they? You can answer that.
You can answer the question.
They could have, but that would not have been our practice.
But you've already told us it wasn't specific that Phillips had to do it. Isn't that correct?
That's correct.
So they could have done it, right?
They could have. It would not have been typical.
And Phillips could have done it rather than standing around in the street for 2 hours waiting. Couldn't he have?
I think
No.
we've gone over this already.
I think you're right. Thank you very kindly. Thank you.
Ms. Clark?
Sir, as a police officer or detective on a scene, would it be fair to state that circumstances dictate your actions?
Would you repeat that question, please?
Yes. For any police officer or detective on a scene, would it be fair to say that circumstances have to dictate your actions?
Absolutely, and they're always different.
Now, if it's unknown who is ultimately going to handle the case, is it reasonable police procedure to wait for the person or detective that is ultimately assigned to the case to make personal notification?
Sustained.
What is the proper police procedure regarding who makes notification when it is unknown as to which detective or which agency will ultimately handle the case? Which division?
We try very hard to make sure that the person who calls the shots is the lead investigator. And if there's going to be a handover, investigative responsibility from one entity to another, the entity that's relinquishing that responsibility always defers to the people who are going to assume responsibility for that investigation. It's very important from the standpoint of continuity.
Now, if the detectives are yet unsure as to the identity of a victim, would it be proper, based on a supposition, to go and make notification to next of kin?
If you did not know who the victim was?
If you were unsure.
If you were unsure, you wouldn't make the notification.
It would be important, would it not, sir, to make sure that you have correctly identified the victim before you go to notify that person's family, correct?
Oh, absolutely. You wouldn't notify next of kin unless you know for certain that their loved one had expired.
And do you recall precisely what Detective Phillips' language was to you, whether he said he thought it was Nicole Brown or was sure it was Nicole Brown at the time you spoke?
Sustained. Sustained.
This was elicited by counsel.
Nope, not as to who it was, no.
When you issued your order to make notification, did you intend that it be followed whether or not Detective Phillips was sure that it was Nicole Brown that was the victim?
Sustained, it's irrelevant.
Would you expect any detective to make sure of who the victim was before he went to make notification?
Absolutely.
And did you assume that Detective Phillips would do that, sir?
That's a given. That would certainly be among the assumptions I would make.
And did you know whether Detective Phillips had ascertained for sure whether that was Nicole Brown at the time you spoke to him?
Sustained.
Were you aware of what Detective Phillips' state of mind was, or his knowledge was, with respect to the identity of the victims in this case at the time you spoke to him?
Sustained.
What did you know about Detective Phillips' knowledge of the identity of the victims in this case at the time you spoke to him?
Sustained.
Did you have a conversation with Detective Phillips about whether or not he was sure it was Nicole Brown at the time you spoke to him?
Forward to sidebar with the court reporter, please. Anything new?
Yes. In your experience, sir, notification to the family takes approximately how long?
Well, they usually take place after the investigators are through at the initial crime scene.
How long? Does notification usually take several hours?
Well, each case is a little bit different, and it certainly depends on the availability of the person being contacted. There are times when it's a knock on the door and there's a clergyman there, the family's there, and there are other times when it can be quite a laborious process depending on how many people are involved and the degree of grief that's experienced.
Now, I think you indicated before that one of the reasons that you asked that the defendant be personally notified first was your knowledge that he lived nearby.
I seem to recall that I was aware that he lived nearby.
So he would be easiest to reach, was that your thinking?
Yeah, that plus the fact that his children were there caused me to form that opinion.
So even though legally speaking, sir, he was not next of kin, why was it that you...
No, it's not.
Was that...
I heard that officers who have to go and you know, tell the next of kin their loved one died, and service members, you know, that they present the flag and they let them know that they're not coming home. I heard that they get screamed and sweared at often. Like the first reaction is pure rage.
No, it's not.
No, thank you. I couldn't hear you. Thank you. Even though legally speaking he was not
I
next
gotta
of
get my
kin, sir,
phone.
you
I'll be right
indicated
back.
that you felt it was important to notify the defendant first.
Well, that seemed to be the person we could probably get a hold of first, because the children being there, a prominent person, the belief that he lived in that area, he seemed to be somebody who was accessible.
And the children, did they play a large part in your concern for notification?
Absolutely.
Did you go to the station the following morning?
Oh, hold on. This is
I don't
beyond,
re-
wait.
I'm sorry.
This is way beyond the scope of notification at 2:30 in the morning.
It is the subject of notification.
Activities at West LA Station the next morning or not. Proceed. Proceed.
Thank you very much. Who told you that O.J. Simpson lived nearby?
You know, I don't recall specifically, and I've asked myself that question several times, but I'm trying to separate what I knew that night from what I've subsequently learned. And I had the sense, as a result of my conversation with Ron Phillips, that he lived nearby, and I can make an assumption if that's what you'd like.
I don't want you to...
Okay. I cannot tell you exactly why I knew that.
All right. Could it have been that Detective Mark Furman told you that he lived nearby?
Oh.
No,
Could
that
have
absolutely, no, that did not occur.
He didn't tell you that?
I had no conversations with Furman.
Now, you would find unusual that the two minor children that you were so concerned about would know who their father was and where their father lived, would you? Who were at the police station. That would be no mystery, would it?
No, what about the police station?
That you would not find it unusual that these two minor children, Sidney and Justin Simpson, who were at West Los Angeles Police Station, would know where their father lived, would you?
You would think that they certainly would.
And what you've told us here today is when Ron Phillips talked to you at 2:30, he told you that one of the female victim in this case was Nicole Brown Simpson. Isn't that correct?
That's what he believed, yes.
By the way, you talk about these competing interests.
Objection, no motion to strike on this hearsay.
Overruled.
You talk about these competing interests. One of these competing interests is not standing in the street doing nothing at a homicide scene, is it?
If another investigator is responding to take over the investigation, that's probably the thing that they should be doing.
I'm talking about your competing interests, not about another investigator taking over. I'm asking you, you talked a lot about competing interests. And I'm asking you specifically as a commander with the Los Angeles Police Department. One of the competing interests at a serious homicide scene that needs to be investigated is not standing in the street doing nothing, is it?
Objection is argumentative and has an answer.
Sustained.
Thank you very kindly. I have nothing further.
Do you recall whether Detective Phillips told you he was sure it was Nicole Brown?
Objection.
Or maybe was it?
Hearsay.
He was at her residence, and I'm quite certain that there was no conversation that he is absolutely certain that this was Nicole Brown Simpson. I believe that that's what it appeared to be because she lived there, but I'm quite certain that there was, well, I'm not certain. I'm not aware that there was a positive identification, but that's certainly what it appeared to be.
And you had no conversation with Detective Furman that night, correct?
None.
And you told that to Mr. Cochran earlier in his cross-examination, correct?
I believe so.
Can you imagine why he keeps mentioning Detective
Sustained.
Furman?
Sustained.
Thank you.
That's what you're going to answer the last question. With regard to the fact that the detectives were at Nicole Brown Simpson's house, her children were at the police department. Is that correct?
At some point.
Yes. They've been found at that scene. And Detective Phillips told you that she was the victim. Isn't that correct?
Objection, hearsay?
Overruled.
Has been answered.
Isn't that correct?
Overruled.
Our assumption was that it was Nicole Brown Simpson.
Otherwise, you wouldn't tell him to go give notification. You wouldn't give a direct order as commander of the Los Angeles Police Department, would you?
That's correct.
Thank you, sir.
No.
All right, Commander, thank you very much, sir. You're excused.
Thank you.
All right, ladies and gentlemen, we'll take our mid-morning recess at this time. Oh, I'm sorry, we had a stipulation. Mr. Neufeld, you had a stipulation to offer. Is there a problem with the stipulation?
No, but there's a procedurally different. What case we're in. We're both sort of yes. I don't know where.
That was
No.
so good.
Offer the stipulation.
Your Honor, if I may. Good morning. The prosecution and the attorneys for Mr. Simpson have entered into a stipulation. By the way, we need to have this marked. What's the next in order, Your Honor?
1382.
Okay. This should be marked 1382.
I don't know what the counsel.
Yes, she,
I asked for it in writing.
no, she didn't. And this,
Ladies and gentlemen, would you step back into the jury room, please?
Yo, he should have given her the stipulation in writing. He should have. He's trying right now. He's
Now,
trying.
counsel, I realize that we're all tired and we wish this were over sooner than later, but this kind of petty bickering is not appropriate. And if you heard the snickering of the jurors as they were going out, they thought it was pretty silly, too. Now, is there a problem with the stipulation?
I don't even know exactly what it is, Your Honor. How can I say there's no problem?
Well, counsel, this morning, this morning, I was told, on the record, here in front of all of us, there was a stipulation. There was no objection from the prosecution side. It's reasonable for the court to assume that that offer of the stipulation had been made and had been accepted.
That is reasonable, Your Honor, and there was a stipulation. There is one. I just need to make sure that counsel is going to frame it in the way that we agreed. That means I need to see it in writing. Counsel's been told this innumerable times by Mr. Goldberg that that's the way we proceed in this jurisdiction.
You know, it's amazing to me.
Stipulation without knowing what he's going to say, Your Honor. How can I do that?
It's amazing to me that we have to bicker over a stipulation that this is a syringe used by the LAPD infirmary. It's astonishing what we've sunk to here. That we have to argue over waxing and waning. We have to argue over, and the waxing and waning goes to this side, the syringe goes to this side. This is incredible. This is just incredible for both sides. We'll take a recess for 15 minutes. If there's not a stipulation, then we'll have some more testimony, I guess. Thank you.
Please clear the courtroom.
I would give her a piece of paper with two words,
matter?
2 letters on it. F you.
All right, have we resolved our stipulation?
Yes.
All right, do we have any other witnesses to present? What's our scheduling expectation for the remainder of the day?
I need to briefly on Barry Sims, Your Honor, the notes that I promised the court are here. May I also indicate to the court that I have conferred with the members of the Simpson prosecution team, and we have determined that SOP-B is not anything that addresses any part of the people's rebuttal case. We raised nothing in our rebuttal that would make SOP-B relevant on rebuttal. Furthermore, as the court is aware, the defense rested conditionally subject to the reservation of the Whitehurst matter. That's been resolved now, so there is no part of the defense case in chief that is left to be explored. So we neither have a proper admission in the defense case in chief nor on rebuttal. Furthermore, the notes reflect that Henry Lee made extensive physical examinations of SOP-B in April and in February as well. His diagrams reflect that the area to which they wanted direct testimony was located by him and examined microscopically by him. And certainly the April examination was not hampered by any faulty or inadequate equipment. If the defense thought this was so important, then clearly they had all of the knowledge they needed to put it into their case in chief, and elected not to do so. And if I may proffer these notes to the court, or would you prefer?
Oh, I'd like to see the notes, and I'd like to see the photographs if they're available.
The photographs are in counsel's possession. I don't.
All right. Assuming the worst happens, and I determine that Mr. Sims is subject to recall, what's his availability status, Ms. Clark?
I actually called the Department of Justice Laboratory in search of Mr. Sims as the court directed me this morning, and I was informed
absolutely
that today
going
is the day
to.
that he
I'm
takes
trying to think of
classes,
titles in my head.
in the extension school, I believe. And Mr. Konzak from the laboratory told me that he could not reach Mr. Sims and didn't expect
I'm
him
gonna
in the
do it right
laboratory
now.
until sometime after 1:30.
I checked on the availability of Mr. Matheson. He's at school in Sacramento until Monday. And if Mr. DeForest is teaching today until 3 p.m., and he's teaching tomorrow. So this would require testimony next week.
All right, then if you'll submit to me the notes from Dr. Lee, I'll take a look at them over the lunch hour. All right, then I suspect that all we have to offer the jury at this point then is the stipulation regarding the syringe. Anything else we can offer them as by way of witnesses?
I don't think so regarding the jury, Your Honor. May I just indicate to the court a couple of things on the list I have here? I think you might be able to do the rest of it.
Oh, no, we can do lots of things. There's 53 things we can do.
Okay, good, you know. Okay.
Not the least of which is instructions, motions on argument.
Right, we're going to ask you a couple of motions to put, you can move up to the top, so some of us can go on the second period. Thank you.
Okay. All right, then my inclination then would be to invite the jurors to join us, and as far as they're concerned, do the stipulation, then recess for the morning as far as the jurors are concerned. All right, for the day. Charles, let's have the jurors, please. And let the record reflect that we have now been rejoined by all the members of our jury panel. And Mr. Neufeld, you have a stipulation to offer.
Thank you. The stipulation that the prosecution and lawyers from Mr. Simpson have entered into is that this exhibit, which is 1382, is a syringe that is the same make and the same model as a syringe that Nurse Fano Paratus used on June 13th, 1994, to draw blood from Mr. Simpson. And with that, Your Honor, I would ask permission to pass it around so the jurors can inspect it.
All right, in the original packaging, and there's no needle attached, correct?
No, there's a needle attached. There's a sheath over the needle, and there's packaging over the sheath.
All right. Hand that to juror number 14, please.
Thank you.
They can bend the needle if it's used into a wedding ring.
All right, the record reflects that each of the jurors has had the opportunity to examine that item. All right, ladies and gentlemen, at this point, we have no further witnesses to present to you this morning, so we're going to break a little early as far as you're concerned. And just to let you know what the progress of the case is, I now have before me certain motions regarding whether or not I'm going to allow either side to call additional witnesses as to certain specific issues in the case, and I have to decide who they can call and who they can't. I anticipate that we will conclude, as I indicated to you, the presentation of all the witnesses this week and argue next week. And that's still my expectation based upon what I know of the case today. So please remember all my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case, don't conduct any deliberations until the matter has been submitted to you. Don't allow anybody to communicate with you with regard to the case. As far as the jury is concerned, we'll stand in recess until, given what I know about the availability of the witnesses, if I do allow them, they will not be available until tomorrow. So as far as the jury is concerned, we'll be in recess until 9 o'clock. As far as the counsel are concerned, though, we'll reconvene as soon as the jury has been escorted out of the court. All right, thank you.
They didn't actually hand the needle to juror number 7. They passed it right by her. I need a title for this short. Judge Ito walks off bench. Judge Ito Johnnie Cochran pushes Judge Ito too far, even though Johnnie wasn't it. Can't use him. Marcia Clark annoys Judge Ito.
All right, back on the record. All parties are again present. The jury is not present. Counsel, what I suggest we do is set up an agenda for the issues that remain to be resolved before we proceed to the instruction of the jury and arguments.
Thank you very kindly. Thank you very kindly, Your Honor. I think that's very appropriate. We would like to, in addition to jury instructions, we do have some further exhibits I think you're going to have to deal with.
Very few, though. I think
very
we
few.
have
I think Mr. Douglas will be ready on that, plus
probably less than 20.
I think he has a sense of that. Your Honor, what I would like to, and I think Ms. Clark agrees with this, if we could this afternoon, or even now if you wanted to, take up the argument regarding the length of arguments in this case, perhaps first. Number two, Ms. Chapman will be down shortly to argue this, the motion regarding the use of both sides, the ability of both sides to use videotape that's been shown to the jury, and also videotape of the actual testimony in certain instances, which we would have an opportunity to review and get ready. We'd like to take those two motions probably first. In addition to that, Dean Ullman is present, and as the court understands and realizes, we will undoubtedly ask for a further review of our earlier suppression motions in view of the attack on Mr. Van Adder's testimony. We think that issue is ripe again. We did not bring it up yesterday because we wanted to give you an opportunity to deal with Martz. Now that you resolve that, we think it's appropriate. We will be ready to respond to the people's request for a judicial notice motion. And we have several other things that tie into jury instructions. The court will recall the page 4 staple incident. At one point you had ruled, I believe, and indicated that the appropriate time for dealing with that would be in jury instructions, I believe. So that's something we think is very important to us. I've made a final proposal to Ms. Clark with regard to how we elevate this entire proceeding. I'd just like to say something, Judge. We're at the end of this trial, and early on you said to us that we wanted to conduct ourselves in a manner so that when this is all over, we could all go off and have dinner and would be proud of the way we performed in this trial. This has been very hard fought, but I'm hopeful that at the end we can come back full circle to that point. I hope that nothing has happened at this point will cause us not to do that. I mean, everybody's been vigorous. You've done your job. We tried to do our job on both sides, and I hope we can still do that. And I proposed something to Ms. Clark this morning with regard to what we do from this point forward, an argument which I think might help restore some of that.
Well, it's still my fondest hope, Mr. Cochran. As I mentioned, however, to your colleague, Dean Ullman, I suspected that at this point, the invitation was only open to him and Mr. Hodgman, so.
I understand, yeah, and I said the rest of us will be trying to get back on
the dinner list.
invited list, Your Honor.
All right.
We're trying real hard to do that. And I think that's one of the things about our system that makes it so great, that we can fight very hard, and we are very, very earnest in our various positions, and hopefully morally and ethically try to do the right thing. But this is serious business. From our standpoint, as you know, and from the people. We have a client that we've always felt was wrongfully accused, and so we've done everything we could to try and represent him. So, thank you, Your Honor.
All right, well, why don't we take up, Ms. Clark, do you agree with the order? We're taking these matters up?
Yes.
All right, then let's address at least the length of closing arguments and the use of video, if we can, this morning, and then we'll recess until 1:30.
I don't have any of my motions down with you, I didn't realize it would take that right away, so I would like.
Yes, Josh, we are a lot closer than you think.
Would Your Honor consider, we'd like at 1:30 to do those two motions. Would Your Honor consider, Dean Ullman is ready with that other motion, so we wouldn't lose any time. Would Your Honor consider that, the motion to suppress your motion?
At 1:30?
No, he can, well, you're not ready on that. Okay, no.
I do have
Oh,
somebody who
okay.
could argue, but we're not here right now. Everything's gonna take a little bit of time.
Well, it looks like a long lunch hour.
And at 1:30,
Although I must say that, you know, as far as our discussion of the instructions are concerned, we're about a day ahead of schedule, so. And it would thrill me to death if I could instruct the jury Friday morning, then recess, and then start our arguments on Tuesday. All right. 1:30.
We'll agree this. We'll come back with Dean Ullman first, then we'll go right into the argument on time and the other two.
Okay, 1:30.
Speak clearly, courtroom.
All right, back on the record in the Simpson matter. Let's take up the length of argument matter first.
Your Honor, Ms. Clark is arguing that motion. I know she'll be here momentarily.
Your Honor, may I
Of argument.
take care of a bookkeeping matter while we're waiting for her? I just want to make sure that the materials that the court considered on the Martz Whitehurst issue were made a part of the record at some point, because I know you reviewed things that we have not seen.
All right, then let's take up the use of video matter. Can we do that one, Ms.?
That was Mr. Chapman.
All right. Ms. Chapman?
Good afternoon, Your Honor.
All right, good afternoon, please.
Would Your Honor like me to address the people's response? Because you've read my moving papers. Well, okay, I'll just start from the beginning. The defense
Well,
would
let me
like...
just ask you this. Don't you think there are some restrictions we ought to apply to snippets or whatever it is that you're going to use to require that it not have... I notice that from time to time, the camera looks at people in the audience or goes to things that are not specifically the witness or the person who's doing the questioning.
Yes.
Some reasonable restrictions.
Yes, we would not seek to introduce any videotape that had anything other than the witness. We would never want to pan over to Mr. Simpson or any other person in the courtroom. So we can make that assurance to the court that the only videotape of a witness testifying used would be that of the witness's face and demeanor. Okay.
Any other comment? Do you have you prepared any examples of what it is you want to show?
Well, the people talk about in their response that they think that there would be an undue consumption of time in arguing the admissibility. First of all, I've spoken with Mr. Cochran about this, and he intends to only use about 10 snippets of videotape in closing argument. So I don't think that there would be an undue consumption of time in having the court preview the videotape that we intend to use. And I don't believe that Mr. Cochran intends to use any videotape that's going to be considerably lengthy at all in any event. So I think that if we were to set up a time where both sides could be here and preview the videotape that the defense intends to use and that the people intend to use, if at all, that it wouldn't take very long at all. We could possibly do that Friday afternoon.
Do you believe you'd have those available by Friday?
Maybe, if I might just a second.
Mr. Cochran says realistically by Monday afternoon, although I know that that is a court holiday. I don't think it would take very long.
All right.
The people also talk about in their response the turnaround time that they would need to respond by way of videotape. I think that the need to do that would be obviated also by having this preview session. They would then be made aware of what the court's rulings would be with respect to whatever videotape was admissible at closing argument, and then they would have enough time to present to counsel and to the court what videotape they plan to use in their closing argument. So all of that would be before the time for the closing argument. They also speak about taking testimony out of context. I don't see that as being any different from reading from portions of a transcript during closing argument. Obviously, counsel takes certain portions of the transcript, and the people are obviously able to respond in the manner that they feel necessary in their rebuttal. Further, the people say that the videotape is not an accurate representation. I think that it's clearly the most accurate representation of what occurred at the trial. They speak about the angle being non-representative, that the camera is in a different position than the jury view. I think that it's very close, very similar, and I don't think that that should be a reason that the court should not allow the use of videotape. I think that I have addressed all of the arguments the people presented in their response, and I'm available to answer any questions the court may have.
All right, thank you,
The last thing I just want to say is that we looked up California law. There was nothing on the subject, but I did find some out-of-state cases, Illinois court, Indiana, and Georgia. All of them say it's basically at the court's discretion, and there are a number of cases which have allowed the use of video and audio tape in closing argument, as well as graphics, obviously.
Counsel, I realize that we're all tired and we wish this were over sooner than later. Ms. Lewis.
Good afternoon, Your Honor.
Good afternoon.
Your Honor, every criminal case in this country has been argued and is currently argued and will in the future be argued based on the court record in the case and perhaps illustrative charts that either side may use. In this courtroom, we're particularly fortunate for this case to have use of the Elmo and the graphics presentation that has been made available to the court and to counsel for both sides throughout the trial, in which we'll continue to have 4 closing arguments. That alone is a unique feature of this trial that is not enjoyed by the vast majority of criminal cases that are argued throughout this country. Now, when it comes down to the particular media videotape and broadcast, there are definite problems with it. And frankly, one of our concerns is that whatever the defense may choose to use may be taken out of context. Now, when you're talking about a reporter's transcript where the arguing counsel has to cite the page and line, it's easy in most cases, though in this case, actually with 200-something volumes, it wouldn't be fast. But normally in the normal criminal case, it's easy to pull out the transcript and see what the context was in. We don't have that quick turnaround ability here. Even if we were given some...
Breathe. Breathe, Lois, breathe. I got that short. It's already up. I made it.
Amount of time to preview what Mr. Cochran, and I assume he's the one who's going to argue, intends to use, and anyone else who's going to be arguing on the defense side. Even if we had the opportunity to preview that, we would have to, there would presumably, because there usually has been throughout this trial, there would be reason for objection. We would be making those objections. It would take us time to find the context. We might make representations to the court, but we'd have to go back and look. And frankly, it's difficult, especially with the, we're grateful for them, but they are government videotapes that we have. We don't have counters on any of our videotapes, so that it's on any of our video equipment, I mean our VCR playing equipment upstairs.
You're kidding.
No, we don't. I was shocked when I first discovered that, but unfortunately we don't. So it's very difficult to search through, as you can imagine, because you have to stop and listen periodically to what's being testified to, and it's a very, very difficult process, as we're discovering at the moment, to find things on the videotape. So the practical difficulties are going to create problems. In addition, there are some other difficulties.
So are you suggesting that the prosecution is at some kind of technological disadvantage in this? I mean, do you have access to the same tapes that the
We have
defense
access
has?
to the same tapes. No, Your Honor. I'm just suggesting that it is a practical difficulty when you're talking about videotape testimony, to go through and find the context that the defense may cite with regard to any particular witness's testimony. In addition, throughout the broadcast of this trial, as the court just mentioned, there are many times when the camera is focusing on other counsel, on the court, on members of the audience, on the defendant's face. And even though defense counsel concedes that that would not be appropriate to show, there are instances where that happened when the witness was giving critical context testimony. In addition, in recent months in particular, for a good reason I'm sure, the stations who have been broadcasting have been cutting away frequently to commercials, because I understand their revenue was down when they had high ratings but no commercial time. So there are many times now currently, which I don't know if the court's aware of this since you're in here on the record, when they're breaking away to commercials. And, Your Honor, the point of that is that we may not have a context. If the defense comes up with what we believe are misleading clips, there may not be a context available from the live broadcast readily available for us to supply the context.
Well, Ms. Lewis, let's suppose that as one of the requirements, I've already indicated that a likely restriction would be that the videotape would only be of the witness testimony only, no other views allowed, that these would have to be previewed, and any preview was likely to require a citation to the transcript as to where it's coming from, so that both sides have the ability to look forward and backward and both sides have the advantage of having the real-time transcript on your computer disk. You can do word searches back and forth. I mean, it's pretty easy to find. I mean, that's why I've given you all this
And
fancy schmancy stuff.
all of that is wonderful when it comes to the record. And as most attorneys rely on when it comes to closing argument, we all rely on the record when we want to quote what a witness has said. The media broadcasting is not part of the record in this case. And for the practical difficulty, which I mentioned, in terms of searching the videotape, searching the disc is not a problem. But to have the jury presented with something that a witness has said out of context, and then to stand up here and dryly read the context testimony, or even put the context testimony in writing on the Elmo, doesn't make up for their advantage, that side's advantage in having shown the live testimony as to the point the defense wanted to make critical. Now, there's some other problems in it as well, as which I've set forth in the brief, so I won't go on at length. But the angle of the camera is at a high angle. It is higher up in the courtroom and points at the witnesses in a downward angle and quite to the side, so that the demeanor observed by the lens is not the same demeanor that these jurors who are sitting either lower than the witness or substantially level with the witness enjoyed. So that the demeanor is not even the demeanor that was had on the record, if there could have been a record, in terms of the eyes of these jurors and what they saw when they looked straight across at the witness testifying. It's not the same angle, so it does not portray the same image that these jurors captured in their mind's eye. So it's not a truly representative angle. And it reminds me of, I'm not that big a sports fan, but in football games I know there's been quite a bit of controversy over use of the instant replay, because depending on what angle is captured, something may or may not appear to have been so. Now this is less important when you're talking about a person talking, but it still demonstrates the point that it is a different perspective from what the jurors had. So it doesn't necessarily at all record or be the best recordation of that witness's testimony. So, and Your Honor, we've heard throughout the course of this trial from both sides on what everyone's intentions were, and intentions when it came to witnesses and intentions when it came to who was going to be called by either side. And Ms. Chapman makes the point about Mr. Cochran's intentions at this point in time. Suppose after the people's opening argument, perhaps Mr. Cochran might want to change his intentions with what he uses. That would consume time throughout the trial and throughout the closing argument and during argument. There's additional practical considerations. We're not ready to preview if the court does allow this. The prosecution is not yet in a position to be able to show the other side what we have, and I can't even make an accurate representation yet to the court in terms of when we would be able to do that. Monday is a Jewish holiday, and the lead prosecutor in this case needs to be here for something like that, and that would certainly be unfair of the court to require any preview be made on that particular day. So that there are a lot of practical problems, Your Honor, and we do enjoy, as I mentioned, the benefits of this elaborate graphics presentation system through the Elmo and the monitors to the jury, and that can be effectively utilized as well as all the traditional means, and as well as any videotape which was shown during trial and was entered as an exhibit. Any evidence that came into the case as evidence, of course, they can use the visual equipment to portray that. So both sides will have the luxury of, if there's any videotapes they want to display, of having that ability of displaying some live action, for lack of a better word, to break up what might be a monotonous argument by doing that. So the practical problems clearly outweigh any usefulness that this could have. In addition, Your Honor, it's very likely, given the number of witnesses we've had in this case and the vigorousness with which it's been litigated on both sides, that this would prolong the length of closing arguments for both sides, not only in litigating what's going to be used and allowed to be used, but in the actual presentation of these things, because they'd have to be explained and set up in advance as to what the witness was saying at the time. And the court, I know, is eager, as are the prosecutors, to get this case to the jury. That is our foremost consideration. And this is something with regard to closing argument that has too easy a potential to be misused. We do not enjoy practical ease in terms of the technology or the turnaround time with which we'd be able to glean the context in situations where the defense might want to use it. And the court, I submit, the court's exercise of discretion should be in favor of not allowing this for either side. It's simply not necessary, and it could easily cause prolonged litigation, undue consumption of time, both before and during closing argument.
All right, thank you, counsel.
With respect to Ms. Lewis's concern about the practical aspect of this, it seems to me that it's far more practical to preview the videotape than it would be in a normal closing argument situation where counsel would simply refer to reporter's transcript and then opposing counsel would have to look up the transcript at that moment without any prior warning at all, except for at that moment's time. In this manner, we're going to have a day before closing arguments where the people will have an opportunity to see everything that's going to be presented. So it's going to run much more smoothly than it would if simply a transcript were used.
But Ms. Lewis does raise the issue that we have agreed to be in recess on the 25th.
It's my belief that this preview session is not going to take very long. I really don't anticipate that. that the defense is going to use a great deal of videotape. I don't expect that the prosecution is going to use a lot of videotape since they're opposing this motion. So whenever we do it, I think it can be done in a short amount of time. We can do it first thing Tuesday morning.
When do you anticipate your side would be able to isolate those passages, at least by reference to the reporter's transcript? Say by 5 o'clock Friday?
Yes. By 5 o'clock Friday.
All right.
Okay. With respect to Ms. Lewis's arguments regarding the angle, Mr. Blasier points out that each of the jurors had a different perspective from one another. So I really don't think that that is of primary importance. And it's also interesting that the people are arguing about the time limits in closing argument. It was the defense position that closing argument itself should be limited in terms of time, and the prosecution wants to have an unlimited amount of time to argue. Obviously, since we're arguing for a limited amount of closing argument time, then we would fit our videotape into that amount of time. As I've emphasized over and over in this argument, we don't intend to use a lot of videotape. I don't think it's going to take a lot of time for the court to preview, and I don't think it's going to take a lot of time in closing argument itself.
I suspect that all 10 of these snippets aren't going to come as any surprise as to which 10 they are.
I don't think so.
I don't think it's like 10 in that range, yes, but I think you can probably guess.
I could guess as to which, I could guess at least as to 6 or 8 of them.
But it seems like we should cross this bridge almost when we come to it. The court is going to have to make a determination at some point as to what is appropriate with respect to the exhibits and graphics, and we just like to put the video and audio tape along in with that. Obviously, if the court finds something inappropriate in any of the graphics or demonstrative evidence or videotapes, the court will say so and rule that to be inadmissible. So we're asking for an opportunity to preview to the court and counsel what we intend to use, and then the court could make its ruling at that time.
All right, thank you, counsel.
May I make a couple of additional points, Your Honor? Please, briefly.
If it's absolutely necessary, Ms. Lewis.
We don't have all of the tape proceedings in this case. We have made a valiant effort to do it throughout the trial, but there have been times when equipment's malfunctioned and other times when we simply didn't do it. So not only is there a practical problem from our point of view in locating context and so forth, but we may not even have the tape, even if assuming there was live coverage. And there's an additional point which I did raise in my brief that I wanted to mention, that there are many instances where I think in every instance, if I'm not mistaken, the logo or channel number of the broadcaster is visible at some portion of the screen, which would have to be excised out. It would be inappropriate to draw the jury's attention to the fact that the media has been broadcasting this. I know they're aware of it, but that would only heighten it when they're staring at a witness, since they're not allowed to watch television coverage or anything like that when they're back at the hotel, since they've been sequestered. In addition, there are comments that appear in much of the live coverage beneath the witness, just a description of what they're testifying to or some context, which is perfectly appropriate in terms of the media providing entertainment to their viewing audience.
I'll be right
but
back.
Totally inappropriate again in terms of appearing to have some kind of official endorsement because of the professional manner in which it's displayed of any description of the witness. May I have just a moment? In addition, if any of the footage that's used is news coverage of the any portion of the testimony as opposed to the Channel 5 or CNN or Court TV's live broadcast, that too is going to be demonstrated by whatever it is that's on there with the symbols and the statements and so forth. And of course, that would highlight totally improperly whatever that news organization felt appropriate to show that day. That would give it extra emphasis or extra authority or extra deference that the jury, of course, is not allowed to give it, and that would be a distraction as well. There's a lot of practical problems from our humble points of view as civil servants with I know there's a lot of us on this case, but we still have limited abilities and limited technology and limited dollars, especially to spend on something such as closing argument when we do have these wonderful courtroom graphics available to us.
All right, thank you, counsel. All right, the request to be allowed to use videotape, quote-unquote, snippets of testimony during the course of argument will be granted under the following terms and conditions. The snippets or the outtakes that can be used may depict the witness and the witness only, that it must come from videotape that is available to both sides, that the defense should file by the close of business Friday, which I will deem to be 5 o'clock p.m. on Friday the 22nd, the transcript citations of the excerpts that they wish to use. Because the prosecution has technical disadvantages, apparently, I'll allow them leave until Tuesday morning the 26th to submit their citations, no, counsel, to the transcript. And we will have the screening of the snippets or any outtakes in reference to the transcript at 8 a.m. on Tuesday.
And Your Honor, you said file by 5 p.m. Did you mean to indicate as well the defense should fax or somehow supply a copy?
Yeah, well, I assume you all still will be here Friday afternoon.
We will.
All right. All right, but the court will preview each one of the outtakes that are to be used.
Thank you.
All right, thank you, counsel. All right, length of argument. I thought
Was
we...
Mr. Yeoman trying to catch a plane out? Perhaps he would enjoy doing the motion to suppress.
No, I'm here.
We are endeavoring to get Ms. Clark down here immediately.
Okay, no, I mean, I thought we had agreed on the order of our discussions, that the length of the argument was going to go first and then the videos. All right, well, let's move on to the additional motion to suppress. All right, good afternoon, Ms. Clark. Are you prepared to go forward with the length of argument discussion? All right, Mr. Cochran.
I think it's kind of poetic justice that as I stand before you to argue the length of motion argument for closing argument, I want to make this a short argument. I think that's very appropriate. Our papers, I think, would speak for what we're talking about here, Your Honor. We've all talked to them for 2 or 3 days based upon some idea that this case is complex. They've heard the evidence. You've said so many times, Your Honor, these are smart people. They've heard the evidence. Certainly, we hope they've kept an open mind, but they know what they feel about all these witnesses at this point. I think some of your recent rulings have tried to tell us enough already, and that's really the theme that we picked up here from you and from the jury. It seems that everybody understands that except the prosecution. And so, toward that end, we've said, given this case, given all of our experience in trying cases, we believe that we should be able to concise our arguments, even with videotape, into one full day, both sides. Where if Ms. Clark starts to argue on Tuesday, she has from 9 until 5 or whatever hours you said. If we start to argue on Wednesday, we have a like amount of time. In fact, I think what we really are saying is that she has perhaps a little bit less than we do because in the total of her argument, it's going to come to the same amount. In other words, she wouldn't have all day Thursday to try and rebut what we do on Wednesday. That would be unfair. I think we'd all agree. But at any rate, what I'm concerned about is that she gets up and tries to argue for like 2.5 days. And then let's assume that she does that. Let's assume that they're unwise enough to try to argue for 2.5 days next week. We would then be to Thursday afternoon. You're going to be dark on Friday and Monday. What are we to do? Start my argument on Thursday afternoon, then come back on Tuesday? I want to tell you, I had that experience in an opening statement. That's not fair to Mr. Simpson or to the jurors. And so I think...
That might be ideal timing for you because you could leave them with the last thought over a long weekend.
Well, if I thought I could finish it in a half day, that might be ideal timing. But I think, Your Honor, we need a little more than a half day. So what I'm asking really is just some fundamental fairness at the end. And I'm asking you to do what you've done so very often in this case, is use your discretion. This is an area of discretion. You want to protect these jurors, and that's all we're saying. We're not trying to dictate anything anybody does. Because in the final analysis, we have to use our own good judgment. And I think Ms. Clark will do that also. But it seems to me, as very often in this case, we need some guidelines to help us use our good judgment. And all I want is fairness. You know her rebuttal argument is limited to rebut what we have. So if you give us a finite amount of time, if we have 6 hours and she uses 5.5, then she's going to be left with only a half hour at the end. So I think that's the way it should be carved out, and I think that's fair to everybody. I just venture to guess, if you submitted this to the jurors, they'd probably ask for less than a day of argument if it was left up to them. And so I think we have to have them in mind. After all, this is supposedly for them, to tie this case together. We welcome this opportunity, but I think we have to make the most of the opportunity. And in order to make the most of the opportunity, it seems to me we do it in a concise, cogent, persuasive fashion so these people get the message. And that's all I'm really asking. And so specifically we ask that the arguments be limited to 1 day per side, that we understand what's going to happen, and we get this case to the jury by the end of Thursday, September 28th, 1995. This case goes to that jury. And we want to be part of that, Your Honor.
Thank you, counsel. Ms. Clark.
Thank you, Your Honor. We filed a brief with the court in response to this request, and I found it interesting to note that there was case law in the area. I didn't think there would be. People versus Green, it's almost 100 years old. But it has been a recognized principle for over 100 years that the length of argument has to be governed by the length and complexity of the case. As the court has seen, this is a very complex case, made more so by the manner in which it's been tried. It's a physical evidence case. This court knows very well the complexities of a circumstantial evidence premised on physical evidence. We have had enormous amounts of scientific testimony. We have had testimony from a number of experts on each area of physical evidence, blood, hair, fiber, as well as the coroner. It's been extensive. If it was the intent of the defense to get this case quickly to the jury, then the defense did not have to spend almost a week talking to the jury through their expert about the movement of an envelope a few inches because the coroner moved the body. If the defense wanted to limit the time that it took this case to get to the jury, it did not have to question Detective Lang for 8 days on cross-examination. If the defense wanted to limit the time it took to get this case to the jury, it did not have to question Dennis Fung for 9 days. As the court has seen repeatedly, our witnesses have been subjected to the most thorough, blistering cross-examination I have ever seen in 17 years of practice. It has been lengthy, it has been detailed, and I suppose reasonable minds can differ as to whether or not it's been overdone. Be that as it may, many, many issues were raised. We bear the burden of proof. It is very clear that the reason for the defense wanting to limit closing argument is to gain what they perceive to be a tactical advantage. I understand the tactical advantage that they want to achieve here. The defense says that they can tie their case together in just a few hours or maybe a day. That's because they have very little to tie together, Your Honor. This was not a thematic defense in terms of evidence.
I see you're arguing already, Mr.
Yes. Well, it is an argument, Your Honor. Argument about an argument. Only in this case.
Only in this case.
It's true. I think.
No, I mean, that's not true. I mean, in other cases, I've talked to other judges, judge who handled the Night Stalker case, judge who handled the McMartin case, judge who handled the Denny case, and we've all discussed whether or not it's an appropriate exercise of the court's discretion to limit argument. So your basic argument is it's not fair because it's our burden of proof and we have a lot of stuff to prove.
Yeah, that's right. We're the ones that have a lot to tie together. We're the ones that have literally mountains of evidence to weave together with the testimony of lay witnesses concerning motive and opportunity to present as a cohesive fabric to this jury.
But isn't it a very powerful argument that the defense makes that this court should do everything it possibly can to encourage counsel to be precise and concise in their argument, and that a time limit would cause both sides to evaluate what it is that's important in this case and what isn't, what the big picture is, and not get lost in the minutia of 12 days of argument?
I agree with you, Your Honor. I don't think the court needs to worry that the people are going to get lost in minutia. We're professionals. We don't attempt this at home. We would be able to. We are going to make every effort to be as concise as we can. We know that the jury is tired. We know they don't want to hear a lot of words. We know that the best thing to do is get it to them as quickly as we can.
All right, Ms. Clark, taking into consideration the length of the trial, the complexity of the case, the number of witnesses that you've called, the burden of proof, what do you think is a reasonable amount of time for the prosecution for opening and closing arguments?
How can I possibly estimate that, not knowing what the defense is going to do or how long the defense will take, what they'll go into?
What do you think your opening argument is going to be?
How long will it take?
Yes.
I think I can't. You know, Your Honor, it's unfair at this point. We have not, as the court knows, there's going to be graphics.
Mm-hmm.
You know, there's going to be.
Clark,
I can't.
Let me put it to you this way. You know, we discussed at the very beginning of this case limitations on the number of counsel who will argue, and that the court was contemplating a limitation on the arguments. So you should have some rough idea of how long you believe it's going to take.
Very rough. I don't know. The opening portion of the People's case would probably take roughly 2 days. And I don't think that's a long time considering the amount of evidence we have here, a circumstantial evidence case. The problem that I really have is estimating the amount of time on rebuttal. I mean, you're asking me to estimate in a blind. I don't know what they're going to do.
No, that's why I confined my asking you to estimate to your opening argument.
Mm-hmm. I mean, that's a very rough estimate without having paced through it with the exhibits and laser boards.
And I assume that your colleagues will assist you in marshaling all the exhibits. And I've indicated to you that my staff will be available to both sides to organize. I mean, we've prepared Mrs. Robertson's list of exhibits, and we will do everything we can. All of my law clerks will be standing in the wings with exhibits. You ask for the exhibit, and it'll be produced.
And I appreciate that, Your Honor. That will be very, very helpful to us. But a large part of the presentation will involve graphic displays that will not involve the court's cooperation, although we do accept it as the very gracious offer that it is. I would also indicate to the court that the real, I think, intent of the defense motion is to limit the rebuttal by the people. What they'd like to see is their case, their presentation, not attacked as thoroughly as it can be and will be. And that's the limitation they really seek. And that's what would be so unfair. I've never tried a case where the court has imposed a time limit, and I'm not saying that that's precedent for anything. All I'm saying is that I have never, over-lengthy arguments have not been my problem with juries. And I don't intend to break that habit now, given the fact that the jury is tired and we don't want to tax them more than we already have. I think that the court can trust me when I say absolutely that we will trim our sails and be as tight and concise as we can possibly be. But to impose a time limit in a case that has already gone this long with this much evidence produces an unfair burden only to the people. This is a motion that is punitive really only to the people. The defense can get up, raise questions, confuse evidence, misstate testimony that quick. And in a case of this complexity, it's easy to do. Create the confusion and the distortion. It takes something for the people to unravel it and put it back together and put things in their proper context for the jury, and to limit our ability to do so is nothing less than limiting the people's right to a fair trial, limiting our ability to explain to the jury how the evidence has overwhelmingly proven the defendant's guilt. And there can be no justice in that. In what the people propose, we don't propose to limit the defense argument. We propose that the defense take as long as they think they need for their argument, and let me remind the court that the people's opening statement was shorter than the defendant's, even when you put it all together and you take out the delays. So we have precedent here for the manner in which the people present their case. And all I'm asking from the court at this final 11th hour is please give us the chance to pull it together for the jury. After all of the obstacles that have been put in our way with things that we could never have anticipated, we need the opportunity to explain this to the jury in an unfettered manner and to be trusted as professionals that we are, that we will not abuse the jury's patience too much.
Good afternoon again, Your Honor. Your Honor, I'm certainly not going to be personal and talk about misleading and distorting and all that stuff. I want to elevate the discussion. This is not about one side or the other. This is about this search for truth, Judge. And, as we said before, Ms. Clark stands before you and says, trust us. We're going to get this case over with real quickly. They're the same people who trust us, and they took 8 months to put their case on. They talk about 8 months, we had 8 weeks, and they're talking about our cross-examination. So, Judge, you can trust us all you want. I'm saying trust us, but give us some direction and some guidance. That's why you're the judge, and you have not been bashful about doing that. One thing I'm concerned about, Ms. Clark kept talking about graphics. We haven't seen any graphics. I think there must be some. The real reason I'm back up here is we want to see their graphics, obviously, as early as possible before they start, because we're entitled to do that, and she's talking about displays and various things. When are we going to see those? And so I hope the court will take care of that. Let me get to her response. There are complex cases. The World Trade Center case. The judge in that case is giving the lawyers a time limit, 4 hours. We have this all the time. Judges give you, say, counsel, you have 4 hours to finish your argument. You have 2 hours. You have 1 day. This is not unusual at all. Lawyers don't stand up before you and say, please don't do this to us, Your Honor. The people being punished. Lawyers deal with what they're dealt with. When you ruled this morning, you didn't see us crying. We just moved on to the next issue. We don't do that. That's what a professional does. You move forward.
Most of the time.
Well, sometimes. Well, one time we did cry, Your Honor. I have to admit, there was one ruling that made us cry a little bit. But short of that, you have to admit, throughout this whole trial, we have usually moved forward in the water like a shark, and that's what we want to do.
That's a bad analogy.
Well, not a good analogy. Shark's probably not a good analogy. We moved forward in the water like a dolphin. Graceful, hopefully, if that's better. But seriously, Judge, we don't stand before you asking, it's not a question of doing a favor for the prosecution, doing a favor for the defense. This is about 14 people who get $5 a day, who've been here, Judge, since September 26th, 1994. I don't have to tell you that. Tuesday will be the first anniversary. We went upstairs and met these people. We promised them certain things. And we're lawyers. We're professionals. Let's get this case over with. It's not any advantage we're trying to get. If she argues 2 days, I could argue 4 days. I feel so passionate about this case, I could argue from now on. I just have to concise it. This is not trying to shorten anything. She hasn't seen passion yet. I told them once before, they're in the fight for their lives, and now they understand that. And we're going to argue in that same vein next week. Doesn't matter whether I argue 1 day or 1 week. They'll understand how we feel about this man's innocence. So it's not about time. I'm just asking you to step up, give us some rules, we'll abide by them. That's all I'm asking. But for heaven's sakes, we want some time to see those graphics. Thank you.
All right. Thank you, Counsel. Counsel, in contemplating limiting the argument here, I had to take into consideration a lot of things. First of all, the unique facts and circumstances of this particular case, the conduct of the lawyers in their argument to date, the length of time that this trial has gone on, and the increasingly limited endurance of our jurors. The court's experience, I had to go outside my own experience to talk to other judges to see what their experience has been and to hopefully gain some wisdom from them. And in discussing the matter with Judge Tynan, who tried the Night Stalker case, which went on for 8 or 9 months, discussing the matter with Judge Pounders, who tried the first McMartin case, which went on for almost 2 years. And if I recollect correctly, Judge Tynan's case involves 17 counts of homicide. Highly complex issues involved in that case, and just pulling together all the evidence. And my own experience as a trial lawyer. And I recollect one argument that went on for 4 days, where the defendant was charged with 5 counts of murder in a circumstantial evidence case. But I also watched the jurors' eyes when I was arguing to them, and that's one of the great benefits of attorney argument, is that the argument is to the jurors. And when you're arguing to the jurors, you look at them eyeball to eyeball, and you can tell when they're being receptive, hopefully, and you can tell when you're boring them or when you've just said something that they don't believe. That's one of the great advantages of argument. I'm very concerned about maintaining control of this proceeding, especially at this point, given the limited endurance of our jury, and I'm sorely tempted to impose a time limit, but I am not going to do so. And I'm going to trust the lawyers. But by having said that, I will come back to the start of this argument with probably 3 good nights of sleep, so I'll be on the top of my game as far as staying on top of the lawyers. And I will make sure that there is no redundancy and that we keep moving. And I will not hesitate to call you over to the sidebar and tell you to get moving or move on to something else. And I won't hesitate to do that also in front of the jury if I feel it's appropriate. So be prepared, be ready, be concise, knowing that I'm unusually tolerant of lawyers, but this jury is going to have the last say. All right.
Can we inquire about the graphics and how we're going to see those? And
That's another issue, counsel.
Okay. That's
Another issue.
We need to know about that. And also, there's a question of point of information. Your chief, Ms. Clark does take, let's say, 2 days, and there's a chance there will be a break in our argument.
I understand that.
We're setting concrete on the 28th.
Unfortunately, we are. When I made those plans, I had no idea we'd still be here
I'm not actually changing plans. I just want to make sure that you
a year later.
Yeah, that's it.
Okay. Now, those are plans that were made a year ago.
You've got this to go, right?
All right, 1538.5.
You don't have the graphics? No, we don't have our video snippets either, but you guys want to see it, so I want to know when we can see it.
We'll see them before they're used.
Can we see them Friday afternoon or at 5 o'clock?
Tuesday morning, 8 o'clock. Tuesday morning, 8 o'clock.
8 o'clock Tuesday? And that's the time to see them and inject and that sort of thing?
This is the whole enchilada. Be here at 8 o'clock.
Is that everything?
Snippets, boards,
Everything?
everything.
We have for Tuesday, 8 o'clock?
Right.
And that vacates the 5 o'clock Friday? Right?
No, no. I want the transcript. I want the transcript notations.
Okay, all right. Tuesday, 8 o'clock.
All right. Mr. Ullman. Good afternoon.
Good afternoon, Your Honor. Your Honor, at this time, the defense would move to reopen the motion to suppress the evidence seized without a warrant from Mr. Simpson's Rockingham residence on the morning of June 13th, 1994, and all of the fruits thereof, so that this court can consider the testimony received yesterday from Detective Van Adder, from Special Agent Wax, from Larry Fiato and Craig Fiato, as relevant to the motion to suppress. This motion, of course, is based on the same grounds of newly discovered evidence that we asserted with respect to the evidence related to the credibility of Detective Furman. I believe it raises essentially the same legal issues. And we believe that the testimony that Your Honor heard yesterday was not only relevant for the jury in assessing the credibility of Detective Van Adder with respect to the testimony they heard, but of even greater relevance for this court to consider in assessing the reasonableness of the entry to the premises on the morning of June 13th, 1994. Mr. Kelberg posed the question yesterday, what reason would Detective Van Adder have to lie about when O.J. Simpson became a suspect in this case? And the answer to that question goes back to the motion to suppress that was filed in this case in late June of 1994. A motion that created a need for a cover story and a need to stick with that story throughout these proceedings. The first explanation that was ever given of the discovery of the glove is found in the affidavit for a search warrant that Detective Van Adder executed in the morning hours, sometime between 7 and 8 o'clock in the morning on June 13th, right after the glove had been discovered. And it's ironic that among all of the misrepresentations and untruths contained in that affidavit, there is one kernel of unvarnished truth. And that was the statement, while securing the premises, the officers discovered a glove behind the Simpson residence. That the discovery took place in the course of activity that involved the securing of a residence, which suggests that they were engaged in a search at that very moment. And the initial issue we raised in the first motion to suppress, simply based on the representation contained in that affidavit, was that police are not entitled to secure premises until they have probable cause to make a search. So it puts the cart before the horse for the police to say, while we were securing the premises, we found the evidence that we believe now gives us probable cause to get a search warrant to search the rest of the residence. And that's what created the need to come up with another story, another explanation. And that was the first time we heard the explanation that, well, we really didn't go to the premises in order to look for a suspect or look for evidence. The only reason we went to those premises was to notify Mr. Simpson of the death of his former wife and to make arrangements for the disposition of the children. That Mr. Simpson did not become a suspect until we found the glove. Now, that's not to say that there was any legal necessity for them to deny that Mr. Simpson was a suspect. Legally, if an officer has a subjective suspicion of a suspect, that doesn't invalidate otherwise reasonably objective circumstances that create the necessity for a warrantless entry. But the real crux of the relevance of this evidence with respect to the credibility of Detective Van Adder is the inconsistency that it creates in the entire explanation of what was going on that morning, of what the officers were really up to when they went over the wall and started looking around the premises of Mr. Simpson's home. And when you put the context of what they actually did against the alternative explanations, I mean, we have two alternative scenarios here. One is O.J. Simpson was not a suspect. We were only there to make a notification, to make arrangements for the children, and once we discovered that speck on the door of the Bronco, to make sure there weren't other victims on the premises or people who needed assistance. Versus the explanation of what's really going on here is a search. We're looking around for whatever we can find because we want to solve this murder. And the obvious suspect, right off the bat, right off the beginning of this whole process, is O.J. Simpson. If you look at how they conducted themselves once they arrived at the premises, it's much more consistent with the scenario of a search than it is the scenario of a notification. The way they entered Mr. Kalin's room, searched the room, looked through his clothing, the way they questioned the persons who were on the premises, the amount of time that they spent on the premises before the glove was even located, actually entering the premises shortly after 5 a.m. and then finding the glove more than an hour later. The quickness with which they were able to ascertain where Mr. Simpson was and to actually call him and speak to him and notify him, and the glove actually being found after that had occurred. The fact that they didn't even look upstairs. I mean, if their real concern was, we're looking for other victims, the fact that they didn't even go upstairs to see if there were any victims upstairs. All of this activity...
But couldn't that also be argued that if it wasn't intended to be a generalized search for evidence, if they didn't even go upstairs? That's what the prosecution's going to argue.
Well, question whether they possibly did go upstairs, but the fact that they're saying we're doing an overview of the premises to look for victims is hardly credible if they limit that looking for victims to areas where they think they might find evidence. And at that point, there's no question but that the circumstances of the investigative activity they were engaged in led them to look for evidence behind the house. Nothing that they encountered initially led them to look for evidence upstairs. But if they were legitimately looking for another victim, there's no reason that they would not have gone upstairs. So in terms of consistency with their activity and behavior, in the early morning hours, we would contend that all of this is truly consistent with the version that Phil Van Adder offered to the Fiato brothers and to Agent Wax, that O.J. was our suspect from the beginning. It is also consistent with the modus operandi described by Detective Mark Furman in terms of the way he goes about police investigative activities. That a good policeman simply follows his instincts, finds the evidence, and then makes up the explanation or the probable cause or whatever justification may be needed later. And we believe that Your Honor should consider together the newly discovered evidence with respect to Detective Furman's credibility, along with this newly discovered evidence with respect to Detective Van Adder's credibility. Now, I know that Your Honor previously ruled that the newly discovered evidence regarding Detective Furman's credibility did not require a finding by the court that Detective Furman was credible because it really made no difference. His activity, the court found, was corroborated by the testimony of Detective Van Adder. But of course, Your Honor can't simply now reverse the process and say, well, we don't have to worry about Detective Van Adder's credibility because he was corroborated by Detective Furman. There's only two detectives who testified in the course of this motion to suppress, Detective Van Adder and Detective Furman. And we believe that in the face of this evidence that seriously undermines the credibility of both of these officers, the court is left with very little in terms of believable justification for the search activity that went on in the early morning hours. I don't believe Your Honor can simply dismiss the evidence undermining Detective Van Adder's credibility as BS. We're talking about two different incidents that occurred at two different times. We're talking about three different witnesses who heard statements to the effect that Mr. Simpson was a suspect from the beginning. In view of the importance attached to that revelation by Craig Fiato, assuming that he had very important and very damaging information to the prosecution in terms of the O.J. Simpson case, that he would be motivated out of revenge because he felt he had been poorly treated or poorly used by the DAs to make this revelation, suggests that it wasn't regarded as simply BS in the context in which he heard it. And of course, I think what Your Honor really has to ask yourself is whether the BS came from the witness stand or whether the BS came over a beer in a hotel room. I think all of the circumstances suggest that we may have heard more BS from the witness stand than we heard in that hotel room. And finally, this information can't be dismissed as a joke. Now, I was trying to think of what the joke would be for the punchline, O.J. was a suspect from the beginning. And I have to conclude that the only way you can explain that as a joke is that the joke was the Fourth Amendment. And I think we have to ask ourselves whether we can really be surprised if police officers treat the Fourth Amendment as a joke if we don't take the Fourth Amendment seriously in our courts. Believing that four detectives left the scene of this brutal murder unattended and all went to Mr. Simpson's residence at 5 o'clock in the morning simply to make a notification that at that time Mr. Simpson was not a suspect requires us to really suspend our credibility, our credulity. And perhaps the only person in America who would still believe that that was the only purpose of their visit would be a judge ruling on a motion to suppress. If the police can expect when they come to court that the kind of testimony presented in this proceeding will be taken seriously, the game of police perjury will continue. And the only way we're going to put that game to a stop is to start to take the Fourth Amendment seriously, to demand that when police dispense with the Fourth Amendment requirement of a warrant and probable cause in order to engage in search activity, they have to come to a court and get justification, and they can't just make up the reasons afterwards to present a plausible explanation. If we want to demand that kind of police conformity with the Fourth Amendment, then we've got to enforce the Fourth Amendment.
People?
Your Honor, once again, I've sat here and listened to the defense bluster and engage in a lot of rhetoric when it comes to the search and seizure issue. They've attempted to make this report the same points repeatedly with this court to no avail. Now, we have here, of course, some it's not really newly discovered evidence. I don't even know if, frankly, well, I don't know how to characterize it since it's evidence that happened, if it happened, after the testimony at the motion to suppress. So while it's newly discovered, it's also an after-the-fact evidence. At any rate, what I heard Mr. Ullman saying is that they were renewing their motion to suppress the entry onto Rockingham, and that's all they're doing. So I'll address just that focus. And that, of course, was the hearing that was initially heard by the magistrate in municipal court, and which this court has had 2 occasions now to have to reconsider if that would be affected by anything newly discovered by the defense. The most recent being whether the Furman tapes would have affected that magistrate's ruling. The court did not have to reach that issue. Now, there's a couple of reminders I want to make. First of all is that the Bishop case, which is cited within my last response to their last motion to renew based on the Furman tapes, is that court is the one that construes the newly discovered evidence as applied to a motion to suppress made below. And it cautions the Superior Court, which acts as the reviewing court in this instance, that the court should look to new trial motions in determining the standard. And we know from my cited Witkin to the court previously, and we know from the Bishop case itself, that the appellate courts consider newly discovered impeachment evidence as evidence which tends to impress weakly because it doesn't go to the heart of what was testified to, but it's only calling one of the witnesses a liar in something that witness testified to indirectly rather than directly by direct proof of something other than what the witness testified to. So we do start off from the basis that we have many times within this trial on a collateral matter, and that is whether indeed there is any
I don't know that I consider a statement that is in direct contravention to testimony as being collateral.
All right, and as I was saying that, I was thinking I have a reason for saying that, Your Honor. It's a inconsistent statement of the witness who testified. So in that sense, well, it still is collateral. But the main reason I say that, Your Honor, and the point I want to make early on in talking to you about this motion, is that the state of the law now, then, and for a few years now, is that the subjective intentions of a police officer, whether it be to arrest someone, to detain someone, or to enter a residence in exigent circumstances, is not controlling anymore. That was pre-Proposition 8 law, and there's one case in particular I'd like to cite to the court because it's a 1995 case, People versus Hull, Hull, at 34 Calat 4th. I'm sorry, 34 Calat 4th, 1448. And in that particular case, which was 1995, as I mentioned, the defense argued in that case that the court had to determine whether the officer's entry into a residence was both objectively and subjectively reasonable before it could decide the search and seizure issue or whether the entry was appropriate under exigent circumstances. And the Court of Appeal directly held no. That was old law. That was pre-Prop 8 law. You know, we have Prop 8 and Lance W. Remember all those cases, which I know you've heard countless suppression motions with regard to. Subjective intent of an officer no longer controls, and it doesn't, frankly, even have any relevance in the instant situation because all of the circumstances known to the officers warranted what they did. And what I pointed out is the most obvious thing. I won't save it till last, but in addition to the newly discovered testimony of the Fiato brothers and Agent Wax yesterday, the court has heard from Commander Bushey, who said he ordered these detectives to go over to the house. So regardless of whether Detective Van Adder may have considered Simpson a suspect in his own mind, that's not why he went there. And even if that's why he went there, it does not matter, Your Honor, because the law says you look at the objective facts and what would be objectively reasonable for an officer to do, and not what was in any particular officer's state of mind. And that Hull course makes that plain and clear in rejecting a defense argument to the contrary. And it upheld the exigent search in that case.
1448, page.
1448. It may still be in the advance sheets rather than a bound volume, but it's final. Somebody double-checked for me with the Court of Appeals, still published in final. The remitters issued.
What division is that from?
It happened to be 3rd District, Your Honor. But, of course, any state court of appeal opinion is binding on any superior court.
Indeed it is.
As you're well aware, I know.
Yes.
I just like to throw in when it happens to be 2nd District. This one does not happen to be.
No, that's just a professional curiosity.
Mm-hmm. So, Your Honor, here we have a few things for the court to consider. We have whether, and the basic premise, remember, is for you to determine whether this evidence would have affected the ruling of the magistrate below. And I submit that when you look at this in conjunction with the state of the law, which is that the officer's subjective state of mind does not matter, and when you look at it, all of the newly discovered evidence, or the new evidence, I should say, including Commander Bushey's testimony that they were ordered to go there to make notification, it's clearly something of too little import to have caused the magistrate below to grant the suppression motion, and that's basically what had to have happened. And if you recall, as I argued the other day, the Bishop Court indicates that mere relevance is not the standard in terms of whether it would have affected the ruling of the magistrate below. It has to be more substantial evidence, something more substantial, and something akin to what the new evidence would be on a new trial motion that could warrant a court granting a new trial, and would likely to lead to a court granting a new trial based on newly discovered evidence. And as I pointed out the other day, as Witkin and Epstein remind us, for a court to grant a new trial based on a new witness on newly discovered evidence, which goes only to credibility or impeachment, is virtually unheard of. It's just simply not done because it is considered collateral. And so to go back to that, in terms of talking about collateral evidence, this evidence is collateral in the sense that his subjective state of mind didn't matter. Now, Detective Van Adder ended up testifying extensively to that, but I submit, especially if you look at the correct standard that you have to apply in determining whether their entry onto Rockingham was proper, he could have been a suspect. There would have been nothing wrong with Detective Van Adder feeling that he was a suspect if he had. The point is he didn't, but if he had, it is the ex-husband the ex-wife of someone who was murdered. And, you know, that person, until you rule out people and can start to narrow it down, everyone is a suspect, so that anyone closely associated with that person is a suspect. So the point to all this is not that his state of mind is critical in terms of the motion to suppress, but only that the defense has tried to get the jury to disbelieve Detective Van Adder. And it's interesting in this regard that they are only now bringing a renewal of the motion to suppress. I don't know if they watched the news last night, decided maybe they better do it for the record or something, but it's amazing to me that that was not their first line of attack, as it was, I believe, with the Furman tapes. It's only today, as a virtual afterthought, after the jury has heard all this evidence and they've gotten in front of the jury, that they decide, wait a minute, maybe we ought to ask for a motion to suppress as well. So I think their lack of timeliness, well, certainly the court, if it were inclined, could deny it as untimely, but I know this court acts conscientiously and wants to look at it.
Well, no, what happened is during the course of the 1054.7 hearings where this information was first disclosed to the court by Mr. Hodgman and Mr. Yokelson, I discussed with Mr. Hodgman and Mr. Yokelson the likelihood that this renewed 1538.5 motion would be one of the obvious consequences of that disclosure if the witnesses did, in fact, after their interview, testify in the manner in which they did yesterday. And when the disclosure was actually made to counsel, and my recollection, Ms. Lewis, is that you were not present during our Chambers conference where these matters were actually turned over to the defense, that was one of the suggestions that there would be a renewed 1538.5. So this is not something that comes as a surprise to me that this is here. So
Okay,
I think we've all been on notice that this is coming.
Well, it's not a surprise because, and we expected it, and I even wrote a brief in anticipation of it, which I don't believe the court needs to address additional matters which hasn't been renewed. But the fact that we expected it, it doesn't mean we weren't, in fact, we were surprised the opposite. That just actually drives home my point, Your Honor. I don't know if the defense, I don't believe, because I haven't been told so, that the defense ever raised it before today as something that they wanted to do, even though we all expected it because we just had that experience with the Furman-McKinney tapes. So we all knew, and certainly the defense knew, having just brought the motion on the McKinney-Furman tapes, that they had the right to do this. And that's why I'm surprised that they didn't do it sooner, or didn't give notice sooner, or didn't make an issue of it sooner. So I don't think this, let me put it this way. I believe the record supports the court denying it as untimely. However, I know you to be a conscientious judge who likes to not to use that as a ground. So that's why I'm going on to talk about these other things, but it certainly doesn't appear to be timely. Just because we expected it doesn't make it timely. I mean, a lot of counsel forego doing things as tactical matters, that are expected, and that they end up not doing as tactical matters. And this could have been one of those situations, particularly where they may have felt that the gamble was worth it to see if they could have Your Honor have the jury hear it without risking the jury not hearing it by you're limiting it only to a motion to renew and motion to suppress. In other words, so that they wouldn't have the evidence considered for two purposes. Maybe they were afraid you'd split the baby or something and not let them put it in front of the jury if we had it in a motion to suppress. So there are certainly tactical reasons supported by the record why they could have decided not to bring one. And here now that they've had their cake and eaten it too, and in terms of the jury hearing all this stuff, they have nothing to lose at this point by now bringing up this motion at this last late hour after you've already ruled in their favor with regard to all those witnesses, both Fiato brothers and Agent Wax, who testified yesterday. So they have nothing to lose whatsoever now, but I submit their initial lack of notification was a tactical decision on their part not to bring it earlier when they should have timely brought it. In addition, there are additional cases besides the Hull case, Your Honor. That's simply the most recent and is certainly the most on point in terms of being an exigent circumstances case where the officers forced entry into a home. Mr. Yeoman makes the repeated point about the officers' actions once they entered onto the premises. That also reminds me of something. If I recollect correctly, and I think I do because I reviewed this recently, Detective Van Adder's testimony was that once they had been at the premises for something like 45 minutes, they had contacted West Tech. They knew the defendant, West Tech had no knowledge of the defendant being out of town. They saw a light on, I forget if it was upstairs or downstairs, but some light in the interior of the residence. I think they saw a light on outside, and I can hear Mr. Cochran real loudly if you wouldn't mind just cutting it down a little bit. So thank you. So they saw a light on in the residence. I believe it was upstairs, but anyway, it was inside the residence. They rang at the bell. They couldn't rouse anyone. West Tech said they had no knowledge of him being out of town, and that's, I believe, when Detective Van Adder indicated he did become concerned for the lives and welfare of the defendant who was in there. So that flowed naturally. So they did have additional reason, besides Commander Bushey ordering them to notify him for the reasons Commander Bushey articulated eloquently in court. They did have good reason to go onto the premises and try to find him. And their actions once they entered the premises were consistent with trying to find Mr. Simpson. They went up to the front door and knocked on it, got no response. They went to the first guest house, first guest room down there, and knocked on Cato's door. He didn't tell them Simpson wasn't home. He didn't know, or he didn't say anything at that point in time. I guess he knew because he'd helped him pack off, but he didn't. The state of the record is that he did not say anything at that point in time to these officers. So they went on to Arnell's room while Detective Furman appropriately stayed behind to see if there was anything suspicious about this man who looks like Cato looks in the defendant's guest house, considering the murders that had just transpired. Excuse me. He picked up his clothing. He asked, "Are these the shoes he wore last night?" Totally consistent with wondering if he might have been the murderer, to look and see if there's blood or dirt in the bottom of those shoes. And then, the rest is history in terms of Cato describing the thumps and him going to do that. But the other three detectives, all the three D3s, went ahead for their primary purpose, and their purpose, period, to find the defendant. And that's when Arnell initially said, "Isn't he home?" Something like that. And so she wasn't aware. It's also about that time, I think, that either Arnell said the maid was off this weekend, or it was after she let them inside the main house, that they looked and saw the maid's room, which was downstairs, where the bed was made, and it was clear the maid wasn't working that night, so they didn't have to worry about her safety and run upstairs for her. And then they got a hold of Kathy Randa. Kathy Randa told them the defendant had gone to Chicago, and they got a hold of him there. So everything they did was consistent with a search for Mr. Simpson. And for the defense to reiterate about 4 detectives going to the Rockingham for these purposes, Your Honor just heard Commander Bushey say it's not unusual at all in this situation. You have 2 kids at a police station that one of them may have to do something to take care of. You have a grieving family that they indicated it may be appropriate for a detective or officer to stay with until a clergy person arrives. There may be other witnesses to be interviewed. There's a lot of potential things that could happen. So to have 4 detectives go to the home when it's O.J. Simpson, and the police are being especially circumspect to do everything because they know they're going to be subject to higher scrutiny than perhaps they should be, and they have been indeed throughout this case. And I'm not saying higher than they should be, but higher than they normally are, certainly. They were subject to heightened scrutiny. And it went on and on and on, has gone on and on and on. Here we are again, right at the end of the evidence in the case, arguing the same stuff again with regard to their actions. But their actions were proper. Certainly, if only 2 detectives had gone and there had been a need for emergency help, they would have been highly criticized for not having additional detectives available to handle it. So all of the actions and conduct of these detectives when they arrived there and the reasons for arriving, all of them were perfectly circumspect. Detective Furman would have been negligent in his duties as a police officer not to investigate the noises that Cato described on the wall, and he did what was appropriate in that situation. The detectives in this case, acted appropriately throughout all of those circumstances and that timing. And if Detective Van Adder was tired and getting up in years when it came time to writing the affidavit, he may have made some errors, and the court has already found those. But I don't think the affidavit that he made when he was tired after being called up in the middle of the night, when the detective was called in the middle of the night, the affidavit he had to get out quickly for purposes of a search warrant that day, I don't think you ought to consider his credibility in that light. I think you ought to look at the testimony yesterday and the testimony of Detective Van Adder of the 8 days he was on the witness stand. The court had a lot of opportunity to observe him and listen to him and decide for yourself if you find it necessary to decide whether he was credible. And all of that was after the court had to rule on the search warrant affidavit. So certainly the search warrant affidavit is something, they're not re-raising that in terms of Fourth Amendment issues. So I don't think that's what the court should look to in terms of deciding that, indeed, this newly brought motion to suppress should be denied.
4 brief points, Your Honor. First, with respect to the timing of this motion, I don't think it can be seriously argued that this motion is not timely being made within a week of the...
Don't waste any time on that.
Our concern was that the court not have to hear the testimony twice. It was obviously relevant for the jury to hear, and now we're asking that the same evidence be incorporated into the motion. Point 2 is the testimony that we have asked the court to now consider as newly discovered evidence is the testimony of Detective Van Adder, the Fiato brothers, and Special Agent Wax. I did not mention Commander Bushey, And the reason I did not mention him is specifically because his evidence is not newly discovered. Commander Bushey was available to the people at the time the motion was heard before the magistrate. There is no basis for the people to offer Commander Bushey now as newly discovered evidence that was not previously available to the court. But in any event, we would remind the court that there was no testimony by either Detective Van Adder or Detective Furman that they were responding to any order from Commander Bushey. In fact, Commander Bushey was never mentioned by either Detective Van Adder or Detective Furman in the course of their testimony on the motion to suppress. So we would contend that even though he is not newly discovered, Commander Bushey is, for any purpose of this motion, irrelevant. Third point, the issue presented here is not the subjective belief of the officer versus the objective belief of the officer. The issue here is the credibility of the officer. The question here is whether we should believe these officers in terms of the circumstances that they have outlined as giving rise to their reasonable belief that they needed to make an immediate entry and that their purpose in making that entry was to look for victims or to make a notification as opposed to being engaged in a search, either for a suspect or for evidence of a crime. And when you boil it all down, what we have here on this motion to suppress are two police officers, Detective Van Adder and Detective Furman. And on the evidence now before the court, with the newly discovered evidence, must make a new finding with respect to their credibility. This court is no longer bound by the finding with respect to the credibility of these officers that was made by the magistrate. And with the evidence that is now before your honor, the evidence of the Furman tapes in terms of Detective Furman's approach to the investigation of criminal activity and his propensity to simply create a reasonable explanation after the events have taken place. The evidence of Detective Furman's perjury in the testimony in this trial. The evidence with respect to Detective Van Adder's misrepresentations in the affidavit that this court found justified a conclusion of a reckless disregard for the truth. And now the impeachment, the direct impeachment of Detective Van Adder by three witnesses who testify that he indicated O.J. Simpson was a suspect from the beginning. This court is simply left with a record of two liars, and two liars cannot corroborate each other.
Thank you, counsel. All right, we'll take our mid-afternoon recess at the moment. I'll read the whole case and come back and give you my ruling. Yes, please.
Just as a matter of calendaring and how we proceed after that. Will the court consider taking Mr. Scheck's, the people's request for judicial notice when we come back?
I'd like to resolve the Sims issue next.
Oh, yeah, that'll involve Mr. Scheck. Also Sims, and then those two issues, that resolves him so he can then be finished. And I guess I wanted to know, depending on what you rule on that, there'll be a question of whether the jury will be brought in tomorrow.
I'm sorry?
There's a question of whether the jury will be brought in tomorrow.
That is correct.
So we need to hear that.
Which is why I'd like to resolve that
Okay,
next.
let's resolve those two things. Or
Yes.
Those two. Thank you.
All right. Present jury is not present. With regard to the renewal of the 1538.5, I think, there you are, Mr. Ullman is correct, that the court's evaluation is that of the witnesses who have testified in support of the motion at the preliminary hearing, and therefore the testimony offered by the prosecution of Commander Bushey is not admissible at a renewed 1538.5. And so the record should reflect that in making these determinations, the court has not considered Commander Bushey's testimony, since the prosecution may only recall witnesses who testified in the original motion. Having said that, the court has evaluated the testimony of Agent Wax, Craig and Lawrence Fiato, and also evaluated the circumstances circumstances and context that surround those discussions. And the court, in noting the context, that is drinking beer in a hotel room.
Yes.
And standing around smoking.
Yo, did I come back at the right part or what? We're drinking beer in a hotel room? Yes, sir. Please.
on the smoking deck on the 18th floor strike the court as being relatively informal circumstances. And the context leads the court to believe that the comments, if in fact made by Van Adder, and I believe they were, I don't find significant weight can be placed upon them. In evaluating what impact that has on the credibility of Detective Van Adder for these purposes, I find that it does not have significant or overriding impact that would cause this court to reevaluate the original finding. The conduct outside of the Rockingham residence, when viewed objectively, does not indicate a search for the defendant to arrest him or to otherwise invade his home. The officers stayed outside the residence for a considerable period of time. They attempted to get a response from the residents inside and were unable to do so. Rather than at that time breaking and entering, they sought assistance from the West Tech Alarm Company. The West Tech Alarm Company responded. The information that they gave to the officers raised the concerns even more. The indication being is that there was no information that the defendant was out of town or should have been out of town, and that there should have been a housekeeper on the premises at the time who should have been in a position to respond to the knocking and ringing by the police officers. The prosecution is correct that the standard cited in Hull by Justice Nicholson is the standard that is applied to cases subsequent to the imposition Proposition 8, so the court's previous ruling stands. All right, let's move on to the Henry Lee notes and whether the defense should be allowed to recall Mr.
My cup is too big for my hand right now. So I'm using a straw.
Sims. Mr. Scheck, do you want to address that issue?
It really is delicious. It's yummy.
I'd rest on the arguments. I think that...
All right. I just wanted, if you could...
Yeah. You know what, Zach? It was close. It was a close call that I didn't freeze solid. You want to know why? My freaking car. About 3 weeks ago, my heater, air conditioner, just decided to just stay on. Full blast. All right. So I can't turn it down. I can just adjust the heat. That's fine. Well, now it just shuts off. Like, I'll be driving down the street, it's going full blast, and it shuts off. It's 4 degrees. Oh wait, it's 6 degrees now. It got hotter. And now, because it's cold, it makes the situation worse. My resistor is just not good. I'm gonna have to replace that resistor. It's quick, it's easy, so it'll only take me 7-8 months to finish it. But yeah, my heater kept going out, and then it would come on for a little bit, just enough to bring the temperature up a little bit, and then shut off again. It's an easy, quick, cheap fix. It's nothing major. It's not hundreds of dollars. It's 10 minutes of my time, but you know, it'll take me forever to do this.
A word of interpretation on Dr. Lee's notes then. What I have before me, and this is defense discovery pages 764 through 770, and on the
tell me which date.
Marty, you can go swimming.
This is the April 2nd.
Right.
And am I correct in assuming that otolidine tests were done on the BSOC and that positive results were noted inside on the inner surface on the BSOC?
That, it appears to me that in some areas that's true. There are a number of areas on that sock, yeah.
All right, Mr. Scheck, do you have any other explanation as to why the court should allow the recalling of Mr. Sims in light of it? It appears that the defense had possession of the sock at Mr. Taylor's facility in Altadena, which is, a local community here. That the previous complaint was that at the LAPD that Dr. Lee was not given a professional welcome, and was not accorded appropriate equipment. But it appears that at Mr. Taylor's facility, Dr. Lee and Professor McDonald had free access to the sock, were able to test it, examine it microscopically, to take photographs, to do testing. And is there a reason why we should go beyond at this point?
No, I think I stated the reasons before. If the court wants to hear them again.
Well, in light of what I see here, can you tell
Well,
me?
I don't think this makes any difference. I mean, assume, there were early notations by Mr. Sims as to what he saw in November. He was the first person that saw the socks in their pristine form. Then in July, he and Dr. DeForest make additional examinations in light of what the defense witnesses said about the ASOC. They then come up with information that corroborates the fact that there's a wet transfer from surface 1, surface 2 to surface 3 on the BSOC. Now, let's posit, and I don't think these notes are definitive of anything, but let's just posit that our experts missed it, and their experts found it. If it's exculpatory, it's exculpatory.
We're excited that Judge Fleischer is streaming again.
And forgive me for re-asking
So
Mr.
that
Scheck,
was
but,
very
you know, I have a lot
exciting.
of other issues
But
that had
nothing
to
happened during the
So
docket.
when I asked to
It was
revisit
very
an
boring.
issue, I'm not.
No, Your Honor, I was trying to be succinct.
Thank you. Ms. Clark.
I don't think I understand Mr. Scheck's argument, but first of all, the diagrams make it clear that Mr. Lee made the relevant observations back in April at Mark Taylor's laboratory. That's what the otolidine tests are all about. That's why you have the diagrams and the number of pages devoted to SOC B, with I think it lists positive, negative, showing an entire list of testing stains that he did. So they obviously knew about it back in April. Obviously, they chose, for reasons they're most aware of, perhaps they thought that the SOC A stain was more probative, and they could elicit better expert testimony about it. In calling, let me see if I can frame this tactically speaking, Your Honor, what they do in calling only Barry Sims is attempt to put the issue in front of, they have the testimony of Mr. McDonald. Assume hypothetically, Your Honor, that Mr. McDonald looked at SOC B and said, I'm not going to be able to give you your planting theory on this one. It just doesn't look right. There's only a couple of yarns where there's an indicated transfer. You can't say it's transferred from the surface 2. It could be transfer as a result of Mr. Simpson's bloody finger, and I just can't give you what you want on that. So what they do is they call Gary Sims to testify to the few yarns that seem to be, that give a positive result with the presumptive test, his observation of those couple of yarns, and leave it at that, hinging the inference on Mr. McDonald's previous testimony. And that way, they get all the inferences they want and all the implications they want without ever having to be shown up for the fact that they cannot link it up with Mr. McDonald's testimony. It will then be up to the people to set the record straight. Number one, that the surface 3 stain cannot, or can't call it a stain really, so tiny, but what they see on surface 3 cannot necessarily be attributed to transfer from surface 2. Number 2, that if there were planting, you'd see far more than a couple of yarns transferred. Number 3, that it could easily have been transferred by a bloody finger. Or number 4, that it could have been the result of phenolphthalein tests.
Bye, Kelly.
Or number 5, from the way the socks were laying, the toe folded up on the ankle in one photograph, I think it showed.
But let me ask you this, Ms. Clark. One of the things that concern me is, well, let me tell you 2 things that concern me. One, actually 3 things. Okay. One, these notes from Dr. DeForest were turned over relatively recently, at least the ones that were held back for 1054.7 purposes, which I then ordered disclosed, which was within the last week or 10 days. Secondly, Gary Sims was the prosecution's witness who testified to the wet transfer stains on sock A, and did so, I thought, in a very concise way.
I don't remember him testifying.
Thirdly, during the course of our discussions, when we had Mr. Sims back here, the defense did ask for permission to retake him as a defense witness to go into the areas that they wanted to go into at that time. I told them that I would likely allow that. Then you objected, or I think it was Mr. Darden actually who objected, and indicated, no, if they want to take him as their own witness, let them call him in their case. So I said, okay, with that representation, I hate to drag Mr. Sims back, but I did tell him I would allow Sims to be recalled. So I'm kind of in a situation where, because of the objection, we've got to drag him back.
Well, you know, Your Honor, I disagree. The one thing that we did not get to litigate...
And I might add that I think tactically they believe that Sims is a good, believable witness before this jury.
Oh, I don't... Fine.
And for him to say that there's evidence of wet transfer, that's tactically great for them.
Well, number one thing, I do not recall him ever testifying that there was evidence of wet transfer on sake. I remember him discussing the powder that he saw on Surface 3, but I don't recall him saying it was a wet transfer.
All right, Mr. Scheck, excuse me a second. Mr. Scheck, do you have Dr. DeForest's notes, the ones where it does discuss the wet transfer?
I don't think Ms. Clark is disagreeing that Dr. DeForest's notes say
No.
wet transfer. I think what she's saying is that previously Mr. Sims had offered testimony which allows her to argue that the stain on sake is not a wet transfer, but is flaking from fibrils
Right.
that arose
Got
from
it.
the cutting.
Right.
That's precisely why you're in trouble on sock B, because it says something different.
Well, no, I've talked to Mr. Sims. We're not in trouble. Excuse me. But nevertheless, the problem that I have with the defense posture of saying we can recall him in our case in chief is the court did not give us an opportunity to be heard with respect to whether it was an appropriate thing to do. The court is aware this is an unusual posture to be in, but the court is aware that at the time we presented Gary Sims, we were in our rebuttal case. The defense had rested their case, subject to Whitehurst only. They sought no provision for Gary Sims or any other witness. And the people specifically requested of the court that the conditional resting be not permitted to expand the defense case out into the outer realms of the universe just because they had not formally rested. Otherwise, we can go on forever. I mean, we can just keep calling people. So can the people. You know, this has got to end somewhere.
Let
But
me see counsel without the court, please. All right, thank you, counsel. Is the matter submitted? All right, I will allow the reopening for Mr. Sims. I'll direct counsel to call Mr. Sims this evening or later this afternoon, re-interview him with regards to this one particular issue, and make a tactical determination whether or not you still want to present that. All right. Okay, exhibits. Mr. Douglas.
That was the next thing, that judicial notice motion for Mr. Scheck.
Okay.
That way I can go find
Judicial
Mr. Sims.
notice.
Actually, Your Honor, I don't think I know we're not ready, and I've been told the defense is not ready on exhibits this afternoon.
Mr. Douglas, how many exhibits are there?
Your Honor, there are 130 or so of the people's exhibits that they have sought to introduce since we began our case on July the 10th. And then there's a question of those exhibits that the defense has offered since we last had the issue a few weeks ago.
So how many total do we have?
Approximately 160.
All right, Ms. Lewis, when are you going to be ready to do that?
Actually, I won't be arguing, so I'll defer to Ms. Clark as her best estimate of when we'll be ready to handle it.
I assume we're going to do this the same way, that we'll sit down informally, decide which ones we're going to fight about.
you're going to be doing jury instructions tomorrow, right?
I was hoping to do it today, but it looks like we're not going to make it.
During the course of jury instructions, we have people preparing on this right now. So, like, maybe after the
The problem is there's a lot of you and there's only one of me.
on the exhibits.
Exhibits and instructions.
I don't have a feeling for how long the jury instruction argument's going to be.
Well, you've got 42 special instructions offered, so.
I think some are going to be more hard fought than others. It's going to be hard to gauge that. We can be prepared. We have to go through all of these exhibits.
That $50 payment.
Highlighted here are the ones that Mr. Drummond is objecting to. That was 42 from the defense.
All right, well, I'll tell you what, let's hear the motion for judicial notice, and then we'll launch into see how far we get on the other matters.
All right. We don't have the defense objections to our exhibits, and I think that we have almost completed the defense exhibits the last go-around that we did. How many
Just about.
remaining defense exhibits have we not completed in March?
Tell you what, let's do the judicial notice issue now, and then we'll take a break, and I'll take you and Mr. Douglas back in the chambers, and we'll schedule this. All right. I'm sorry? 13. Only 13.
We need the defense objections to ours. They only have 13. That's pretty easy to handle. We need to know what they object to in our exhibits before we can...
Okay, well, we can do this informally. All right, Mr. Scheck. Oh, I'm sorry, Ms. Lewis, you're the proponent of the request for judicial notice.
Mr. Goldberg is
Mr. Goldberg.
Good afternoon.
I knew I'd get it right sooner or later. Good afternoon.
We're asking for judicial notice, Your Honor, in relationship to several questions in 4 areas that were propounded to Dr. Lee. I don't know whether the court had an opportunity to read our request for judicial notice. It's actually fairly brief and succinct, and I hope states our position rather clearly, but I'd just like to emphasize the key points for Your Honor, because I know that you've been covering a lot, as the court has previously pointed out in the last few days. There are 4 areas that we're complaining of. The gravamen of all of them is that in each one of these instances, there were a series of questions that were asked Dr. Lee that had the clear and unmistakable effect of conveying to the jury the overall impression that the prosecution somehow unilaterally determines when and under what circumstances the defense can have access to evidence, as opposed to the court making those kinds of determinations, or at least having a substantial role in making those determinations. And also, these questions were couched in language, and the testimony was couched in language which elicited testimony to the effect that Dr. Lee was prohibited or denied access or wasn't allowed access to the evidence until certain dates. The first such instance, Your Honor, is in relationship to the inspection of the socks, and the court will recall that there was fairly extensive testimony by Dr. Lee about how he felt he was treated at LAPD, and the extent of the time that he had to look at the socks only being 20 minutes. I think he testified, even though in actuality I think he had more, but he implied that it was only 20 minutes. In reality, the socks had returned from the Department of Justice on November the 22nd of 1994, and there was no application to this court to look at the socks between November the 22nd and February the 16th. And clearly the defense could have done it before February the 16th. I think it was the defense that decided to do this at the very last moment before it was sent to the Department of Justice. So this is a wrongful impression that has been created in front of the jury. The second item was that the defense asked a number of questions about the Bronco that were couched in terms of acting Dr. Lee. When were you first allowed to visit the Bronco, or when were you first permitted to look at the Bronco, and words of that kind? They used that sort of language on a number of occasions. On some of the occasions, we objected, and objections were sustained. But this was one of those instances where we felt that the answers to the questions still left the impression that somehow it was the people that were not permitting Mr. Lee to look at the Bronco. And again, this is an area where the defense never made any application for this court or complained to this court about Dr. Lee's access to the Bronco. The third area was in relationship to the inspection of the Bundy crime scene, where Dr. Lee said that he was ordered by someone, I don't know who, we weren't able to confirm this one way or the other, that he could only be at the crime scene for 20 minutes. However, he never made any application to this court, nor was any complaint ever lodged with this court. Actually, what happened is I believe that prior to the time I came on the case, there was an informal agreement, or maybe a formal agreement between the parties, that the people would have reasonable access to the Rockingham location for certain inspections, and the defense would also have reasonable access to Bundy. But the unmistakable impression was left in front of this jury that the only access the defense had was this 20 minutes, and they were ordered that they could only be there for 20 minutes, and they were prohibited from doing the kind of testing that Dr. Lee would have liked to have done. And then the fourth item that was testified to by Dr. Lee is he stated that Mr. Shapiro had told him that the only photographs that they had received from the Los Angeles Police Department in terms of crime scene photographs were second or third generation photographs. As the court knows, both from your experience as a prosecutor and also as a judge, we always provide in discovery original photographs from negatives, which was done in this case and is done in all cases. In fact, I don't even know if we have the capacity to routinely provide anything other than that in terms of photo shooting photographs and then providing second or third generation copies. So the jury has been left with the impression that we gave the defense less than satisfactory evidence. That is clearly not true, and we believe that misimpression should be rectified. Therefore, we are asking that the court take judicial notice, as the people have requested in our application for judicial notice, as to these four items. What the court is being asked to do is to take judicial notice of the law of the state of California in terms of discovery obligations, and inform the jury that people do not get to unilaterally make these kinds of decisions, that applications can be made in front of the court. That is mandatory under the Code of Evidence. And then we are also asking the court to take judicial notice of the court's own files, that certain applications or orders were not sought for these four specific items of evidence, and that is permissive that the court can take judicial notice of that under the California Rules of Evidence. So we would respectfully request that the court take judicial notice of these items in order to correct these misimpressions in front of the jury.
Thank you, Counsel.
Your Honor, this reminds me of that scene in one of my favorite legal movies. I think it's My Cousin Vinny, where the defense lawyer gets up and says, everything that man just said. And I'll just, after the Fiato brothers, it's incorrect, both on the facts and the law. I actually had to go up and look at all the page references here that they filed. And I'm concerned about Mr. Goldberg's page references. He says the defense also implied the defense was wrongly denied access to inspect the Bronco. Now, the questions were, at the bottom of page 43022, Dr. Lee, before I move on to the next series of words, I'd like to ask you briefly some questions about the Bronco.
Zach,
Did you have an opportunity to personally inspect, examine, and look at the Bronco? No. Did you do a reconstruction of the Bronco? I cannot do a reconstruction because I do not have a direct examination and observation of the original condition. That was perfectly clear that he was going to give very limited testimony just from photographs, and he was explaining when you can do a reconstruction and when you can't, and if you don't look at it, you can't do it. He was only explaining the limitations of his testimony. Now, with respect to the examination of the socks on February 16th, Mr. Goldberg is again in error with respect to the motions that went back and forth on access to this evidence. And I don't believe that he was yet active in this case and doesn't have the same recollection of this that I think you and I do. And that was that there was extensive and extraordinary litigation about access to the biological evidence in this case, and when we could do testing and when we could do anything more than simply examining or looking at it, and even then under what conditions and circumstances. And the fact of the matter was that the socks were under examination, and prosecution took the position that they weren't finished testing until Mr. Sims's report was out, and that was in January. Now, unbeknownst to us, if they had actually sent the socks back at some point to the LAPD, unbeknownst to us, it wasn't clear to us that they had finished testing because they were sending them back and moving them back and forth, and they hadn't finished their DNA testing. And as the court distinctly recalls, when we finally, after weeks of negotiation, had reached a plan to send physical evidence to Albany, and Dr. Lee's testimony was completely accurate as to what the terms and conditions of that order was, in terms of being able to look at it and examine it. When we had done that, this whole issue of EDTA testing arose. That is, that the prosecution said we want to do EDTA testing on certain designated items of evidence, in particular the socks. And of course, the socks were the items of evidence that we wanted an opportunity to examine firsthand and do testing on the most. And in your chambers, with Mr. Yokelson and Mr. Hodgman present, I turned to the court and said, well, if we get Dr. Lee down here from that conference in Seattle, can we have an opportunity to look at the socks? And what followed is 100% accurate in terms of Dr. Lee's testimony as to when the terms were, that courier was flying out.
They were about to be packaged up and sent off.
And sent out, and we sat there waiting, and you can bring Mr. Hodgman and Mr. Yokelson down there, and they'll tell you that every syllable that Dr. Lee uttered about what those facts and circumstances were true. And as far as what went on in the evidence processing room, I was a witness, and I know what I saw. Now, Dr. Lee testified to what happened there, and those are the circumstances that they put together in terms of his inspection of the evidence. Those are the boards that Mr. Harmon chose to put in. That was the testimony they chose to elicit from Mr. Yamauchi. Dr. Lee expressed himself clearly about what he thought of it. They got to live with it. They did it. As far as access to the crime scene is concerned, Mr. Goldberg indicates that he is in no position to give a factual refutation as to what the terms and conditions were of Dr. Lee's inspection of the Bundy crime scene. The record is very clear that Mr. Shapiro had sent letters to the police department and had made requests of the prosecution and the people at the crime lab for Dr. Lee and Dr. Batten to have access to the evidence as they were testing it. Ms. Kessler made very clear that that would not be permitted. That was not their policy. They were going to get to deal with it when they wanted to, how they wanted to, and we've had a lot of litigation about access to the evidence. And those were the terms and conditions. He wanted to get the crime scene as soon as possible. Their argument in closing is going to be that some of the observations he made there that day should be ignored by the jury because some other unknown people might have left imprints on the walkway. And we have to live with that, but our access to that crime scene was limited, and they have to live with what they did with it. Those are the facts. He has said nothing here that in any way contradicts the facts as Dr. Lee stated them. Then there was the whole issue of the photographs. I actually looked every one of these cloaks up. And at 42895, all Dr. Lee has said, these are 3 pictures given by Attorney Shapiro. At 43241 to 43242, it's Mr. Goldberg, as I understand, asks if the picture on our board is a photo of a photo. And it was made clear that we had small original photos given to them, and then we blew them up as photos of a photo. That's all that's there. He asked that.
We're going a little later today, just a little, because We're at an hour and 33 minutes-ish. We're at an hour 32 minutes, and there's an hour 50 minutes of this video. This is the last part of September 20th. So we have September 21st, 2 parts. September 22nd, 1 part. September 26th, 5 parts. 6 parts. September 27th, 5 parts. September 28th, 5 parts, 6 parts. Then 29th, and then the end. So I'm going to finish this day out today. Like 10 more minutes, maybe 15.
Question. Then there is testimony on 43276 to 43277, where Mr. Goldberg shows the new and much better pictures that Agent Bodziak testified were prepared in August for purposes of confronting Dr. Lee on the witness stand. And Dr. Lee said, don't have picture as good as this. And then he indicated that even this picture, which was an overall picture of the walkway, was taken at an angle, and it was selective in that it was focused on the Bruno Magli prints and not in any other prints. And that's what he said. Then he was asked something to the effect of, well, didn't you ask for better quality prints? And he said, I asked Mr. Shapiro. He says that's all he had. Now, that raises the one issue which I think, frankly, is the genesis for this whole motion, which, as I'll get onto in a second, has no basis in law whatsoever. But I'm just concerned even about the facts here. And that is, there is a significant motion pending before this court with respect to the contact sheets, because I'm sure the court's recollection of this is pretty clear. And that is, we were asking for these contact sheets from day one. And they're going to have to listen in closing argument to the testimony of Mr. Rokar and what we were finally able to do when we got those contact sheets. Now, the record is indeed somewhat ambiguous. Mr. Hodgman can't recall whether or not we asked him for negatives. The court's recollection may govern on this, because I think some of these requests were actually made in your presence. It's Mr. Neufeld's recollection and my recollection. We did ask for negatives as well as contact sheets, but the point was they were in the exclusive control of the prosecution, and nobody disputes that we asked for contact sheets all the way through and didn't get them. And the contact sheets reveal an extraordinarily important fact about when that picture was taken of Mark Furman pointing to the glove. Very important fact in this case.
I'm sorry, we seem to be on to a different motion. We're all
No.
shaking our heads here.
No, the point is that that motion is pending, and I'm saying as directly as I can, I think this motion is frivolous, and it's done because the court has put that under submission, is going to give that contact sheet motion serious thought, and factually, none of these things even state what they say. He never talked about wrongful denial. He just stated the facts as they were. The citations they make here don't support their position. Now, as for their legal position is bereft of one case citation. And that's for very good reason, because it is a complete misunderstanding of what one can do with respect to judicial notice. They are not asking for judicial notice of a statute or some public record or fact or anything that's laid out in 451. What they're actually asking for is that judicial notice be taken that if the defense filed a motion, or that if the defense, they want the fact that if the defense filed a motion for certain kinds of relief, then the court would have granted it. That's essentially what they're asking for in each of their requests. And it's inappropriate it's inappropriate, period. And what it would really require is for the court to take judicial notice and summarize every single discovery request that was first given to the prosecution and rejected, and all the different motions that went into the litigation of access to the evidence in this case, which was fiercely litigated, including the court's decision that they could continue testing all the way through the case and withhold access to certain evidence. I've tried to look back at that file, and it's numbing. And it seems to me wholly inappropriate for this kind of judicial notice to be taken for which there is no citation whatsoever, that one can take judicial notice about court orders that were not requested, not note the ones that are relevant on point that did make requests, including informal requests to them as was directed to do by the discovery sections. And it is totally not called for in light of the testimony that they cite here. So this application is wholly without merit on the facts and the law, and I submit to the court is really just a make-weight because they're worried about something else that the court still has under submission.
Thank you, Your Honor. Well, that's the first time I think I've heard my cousin Vinny cited as legal authority in a court of law. What counsel perhaps doesn't know is I believe that that citation was overruled in the more recent movie of A Few Good Men. Your Honor, what we have is a situation here where counsel, through his clever phraseology and asking of questions, I don't think it's Dr. Lee's fault, creates certain impressions in front of a jury, which are obvious to anyone that is listening to what is going on, obvious to this jury, which are untrue. And the issue is, does the prosecution get an opportunity to show that it's untrue? Yes, we can. And we can do that by offering evidence. And we could have offered evidence. Or we can do that in other ways that are permissible under the California Evidence Code. That is judicial notice. And when the court is either required to take judicial notice or may take judicial notice, that is an appropriate avenue to take to counter evidence that was offered and impressions that were created in front of this jury. I've already tried to state the factual basis for the record and perhaps would invite the court to look at this again, because it's not just a question of reading the literal language and the very careful phraseology that Mr. Scheck used, but a question of the court evaluating the overall impression that it created and whether it wrongfully created an impression that should be remedied and that should be set straight, that the people are entitled to set straight. Just very briefly, Your Honor, to give the court an idea of this overall statement that I'm making, that in general misleading information was put before the jury. On 42-900, Mr. Scheck asks, all right, now, Dr. Lee, you mentioned before that arrangements were made so that the defense experts, for the first time, could actually examine items of evidence in this case at Albany Medical Center on February the 17th and 18th and 19th, correct? It's not really a complete sentence or thought, but what is clearly stated here is that the first time that they could actually examine items of evidence was on February the 17th, 18th, and 19th, that they didn't have any ability and weren't allowed to examine evidence before then. Similarly, on the very next page, 42-901, Mr. Scheck asks, were you able to, you or other defense experts to your knowledge, were you given an opportunity to actually examine physical evidence by touching it, microscopic examination, prior to the shipment of that evidence to Albany on February the 17th, 1995? And he said, yes. So again, it's making it sound like we did not give them the opportunity. Well, they didn't ask. They didn't make an order, an application for this court. When the socks had been returned on November 22nd, I believe Mr. Harmon sent a letter to say that these socks are back. Between November the 22nd and February the 17th, they could have asked to see the socks, and they didn't. But they have been led to believe, the jurors, that we did not allow them to, unilaterally said, no, you can't see these. The court didn't have anything to do with it. We just said, you can't see them, and they didn't get a chance to see them before February the 17th. It's a misimpression. On 43-030, in relationship to the Bronco, Mr. Scheck asked the following question on line 7. Couldn't get to see the Bronco itself? Answer, no. Then on line 15 by Mr. Scheck, did not see the Bronco itself? No, I did not. Well, what does couldn't get to see the Bronco mean? On 43-022, he's asked the question by Mr. Scheck. Dr. Lee, before I move on to the next series of boards, I'd like to ask you briefly some questions about the Bronco. Did you have an opportunity to personally examine and look at the Bronco? Answer, no. So clearly, again, the unmistakable impression is being conveyed to the jury that somehow we did not give him the opportunity and he was denied access to the Bronco. Sorry, Mr. Cochran, are you finished? Yeah, I know, but it's a privileged conversation with your client, and I can hear what you're saying. Okay, thank you. And then in relationship to the photos on 43-276, he's asked the following series of questions by me. Doctor, did you ever ask the defense to provide you with higher quality pictures? Answer, I get the information, that's all the picture we get. It's total out of sequence, mixed up like a deck of cards. I spend a lot of time trying to make some sense out. Question, but when you got it from Mr. Shapiro, did you say, please send me some examination quality photos? Answer, I did ask it. He said, that's all he get. He took it back right away. I don't have the photograph. Now, Mr. Scheck, when he read this exact quote, he said that Mr. Shapiro said, that's all he has. He didn't say that's all he has. He said, that's all he get. Well, who did he get it from? The people. So again, what is clearly being stated is that all we gave him were photographs that were not examination quality. Look, you know, I don't know why the defense does this. I don't know why they create misimpressions that are very easy to rectify, that are very easy to set straight either through evidence or through the provisions that are allowed by the California Evidence Code, and then complain when we try to do it. But Mr. Scheck did this. The questions are obviously very, very carefully worded and carefully phrased. But I think now we should have the opportunity to set the record straight. And under California law, judicial notice is an appropriate way of doing it. We are simply asking the court to take judicial notice of what the law is. It's a correct statement of law, that the court can decide when access can be granted and denied to evidence. And we are asking the court to take judicial notice of its own files, that such applications were not made. And we would ask the court to do so.
All right. Thank you, counsel. All right. Under ordinary circumstances, a request for a court to take judicial notice of certain facts, statutes, one of the basic requirements is that either there be no reasonable dispute as to the fact or circumstance that the court is asked to take notice of, or that the facts are easily susceptible of determination. These discovery issues were hotly contested throughout this case. There remains controversy today. There's nothing that we agree upon here between the sides. These are matters that could have or should have been resolved during the course of the examination of the witnesses in question. The request for judicial notice is denied. All right, scheduling of exhibits.
May I mention there's apparently an additional litigation that needs to happen. The court recalls the Gretchen Stockdale issue where we served her with a subpoena. She said, I gave them to the defense. We tried to get them from another source, and I believe the court was carbon copied on a declaration indicating the original source erased them in their normal course of business. And apparently, thereafter we asked the defense for them, and well, the note I have indicates that the defense destroyed it.
Well, let me ask you this. Do we anticipate litigating this? Because the indication I got from Ms. Clark is that both sides, subject to a final decision as to Mr. Sims, were going to rest, so there's no point to going into Gretchen Stockdale unless somebody's going to call her as a witness.
Well, this note has just been sent down from Ms. Clark.
That was my understanding further, Mr. Shapiro.
All right, well, may I just indicate it's still on the plate since they're going to call Gary Sims, the court's allowing it. We haven't yet decided not to litigate this. That's the note I just got from Ms. Clark, so apparently she wants to litigate it.
The problem is, I don't want to get hours late, but there has to be a reason. She just can't walk in and call Richard Stockdale. There has to be a reason to rebut something. And so that's what the law requires, and so they don't have that. They said they've rested. The Gary Sims issue is something came up before, but I'll ask you to take it up tomorrow when Shapiro's here, Your Honor, if we're going to deal with it at all.
Yeah, Mr. Shapiro was the one who was handling that aspect of it. Okay, what we have left then is the motion for an instruction regarding the contact sheets, the instructions in general, and exhibits.
I think Mr. Hudson is most familiar with the contact sheet issue. Is that something that has yet to be
No,
argued?
that's under submission at this point. But that was a request for an instruction, so that's part of our instruction discussion. Who is going to handle the instruction discussions?
The instruction
For the jury instructions for the case?
Yes.
I believe we anticipated handling that tomorrow because I may be mistaken, but I think Mr. Kellberg's going to handle that for our side, and he teaches, I think.
Okay. All right, are there any of the exhibit matters we can resolve this afternoon?
Your Honor, Court, please, I
Mr. Douglas, good
have the
afternoon.
majority, although Mr. Scheck and Mr. Neufeld have not yet given me their list. But we can begin perhaps with my identifying those exhibits to which there are objections and start the process in that manner.
All right, why don't we do this then? At this point, I would suggest then that,
Ms. Clark designated me in her absence if you wanted to do it informally in chambers.
yeah, I was about to say, why don't we just take a recess and formally go over we'll have Mrs. Robertson gather up the exhibits that have been introduced after this certain date. We'll just take them one at a time, and then we'll litigate. After we pare it down to the ones we have to fight over, then we'll take care of those.
There's an additional motion pending that Mr.
Your Honor, there's the Henry Lee notes discovery violation motion. The court had ruled that there was a discovery violation in the late disclosure of certain notes related to Dr. Lee, but the court had not imposed any sanction. Asked the people to file a statement of what the prejudice was, which we did on September the 11th of '95, and whether the court had the opportunity to read that.
Something that had slipped my mind for a while lately.
I know Mr. Goldberg expended considerable time and effort in detailing the prejudice that we suffered for the court's instruction. So.
All right, we'll take that up during the course of our instructions then.
One more beside you on that, I think. One thing, Your Honor, that I was going to say, I was just talking to Mr. Scheck about it, so some of us may take our leave, but if in the event, how long will the court expect to be here? In the event that Mr. Scheck speaks with Gary Sims and there's some resolution one way or the other, we'd like to let you know this afternoon. It might have
I will
something to
be
do.
in the courthouse at least until 5:30.
Right.
And as you know, Mrs. Robertson can always get in touch with me.
Right. We may try to let you know something by that.
Yeah, I would appreciate
I think
that.
that's appropriate, Your Honor.
All right, then what we'll do is we'll stand in. Let me ask you this. Ms. Lewis, do you know when Mr. Kellberg would be available?
In the,
How early tomorrow morning he would be available? Dean Ullman, are you available as early as 8?
Mr. Kellberg gets up beyond my wildest dreams at ungodly hours of the morning. That's just his normal schedule. I did need to make a phone call, Mr. Hodgman, make
Mr.
sure
Manning.
that was a designated person.
I don't think it's Kelberg. When he left this time, he said he wasn't coming back anymore.
I think he meant
He
today.
promised that before. He said that.
Mr. Ullman, are you available at 8?
I'm available at the court's convenience.
All right. Why don't you check and see if Mr. Kelberg is available? We'll start our informal jury instruction conference then at 8 tomorrow morning. I'd like to get this done tomorrow because I'd like to instruct Friday. All right. We'll take a recess. I'll have Mrs. Robertson summon up the items, and then we'll have an informal conference on the exhibits. Anything else?
Anything else? Anything else?
Always afraid to ask that.
I know. We're always afraid when you ask that too, Judge. We just are. We made it to September 21st. So we have 2 hour, 1 hour. Oh, no, we only have 2 videos for September 21st. 2 hour, 2 hour. 26, it looks like a big day, but it's not. It's 1 hour, 1 hour, 1 hour, 2 hours, less than an hour. So it's the same amount of time. It's just different. It's squeezed into 6 parts. It's not the same amount of time. I just exaggerated, but you know what? It's fine. It's fine. It's fine. It's fine. Guys, thank you so much for coming out today. I appreciate it. I do. Time for us to go rest. There'll be a stream tonight, and I'll see you there. I'll see you tomorrow morning. Have a great day, guys. Bye.